Good morning and welcome to the 29th meeting of the Health, Social Care and Sport Committee in 2025. I've received apologies for this meeting from Paul Sweeney and Jackie Bailey is joining us as substitute. Our first and only item on the agenda today is consideration of the Assisted Dying for Terminally Ill Adults Scotland Bill at Stage 2. I will start by noting my intention as convener that we will not go beyond the debate on Amendment 226 today. That is the debate on the group entitled Vulnerable Adults. I will briefly explain the procedure we will be following during today's proceedings for anyone watching. Members should have with them a copy of the bill, the marshalled list and the groupings. These documents are available on the bill webpage on the Scottish Parliament's website for anyone observing. I will call each amendment individually in the order of the marshalled list. The member who lodged the amendment should either move it or say not moved when it's called. If that member does not move it, any other member present may do so. The groupings document sets out the amendments in the order in which they will be debated. There will be one debate on each group of amendments. In each debate, I will call the member who lodged the first amendment in the group to move and speak to that amendment and to speak to all other amendments in the group. I'll then call other members with amendments in the group to speak to but not to move their amendments and to speak to other amendments in the group if they wish. I will then call any other members who wish to speak in the debate. Members wishing to speak should indicate that by catching mine or the clerk's attention. I will then call the member in charge if they have not already spoken in the debate. Finally, I will call the member who moved the first amendment in the group to wind up and either press the amendment or seek to withdraw it. If the amendment is pressed, I will put the question on the amendment. If a member seeks to withdraw an amendment after it has been moved and debated, I will ask whether any member present objects. If there is an objection, I will immediately put the question on the amendment. Later amendments in a group are not debated again when they are reached. If they are moved, I will put the question on them straight away. If there is a division, only committee members are entitled to vote. Voting is by a show of hands, and it's important that members keep their hands raised clearly until the clerk has recorded their names. If there is a tie, I must exercise a casting vote. The committee is also required to consider and decide on each section and schedule of the bill and the long title, and I will put the question on each of these provisions at the appropriate point. The question is that section 1 be agreed to. Are we all agreed? I call Amendment 143 in the name of Jeremy Balfour, grouped with Amendments 4, 144, 24, 73, 26 and 84.
Good morning, Convener. Good morning, Committee and other members. Thank you for having us along this morning to discuss very important amendments. If I can talk to 143 and 144, Convener. Firstly, in regard to 143, as the bill stands at the moment, the definition of terminally ill is extraordinarily broad. As it stands, it would include individuals who could live not for weeks or months, but for years. People managed in long-term conditions, people receiving treatment that stabilises their illness, people who still have meaningful time ahead of them would all fall within the scope of the bill as drafted at the moment. I don't think that is what members of this Parliament, or indeed perhaps more importantly, the public imagine when they hear the phrase assisted dying. They think of someone in the very final stages of life, perhaps days or weeks from death, not someone who still has years to live, but is facing difficulty, fear or despair. If the law is to mean anything, the definition must be clear as this bill goes forward and if ultimately it becomes an act. Otherwise, future generations being risked the expanding the reach of assisted suicide far beyond what advocates publicly claim to intend and the member has stated publicly. This amendment seeks to restore that clarity. It would define terminally ill as a condition which, in the opinion of two independent registered medical practitioners, can reasonably be expected to result in the person's death within 3 months. This is not a technical tightening, it is a moral safeguard. It ensures that if the Parliament does choose to go down this path, it does so honestly restricted to those who are truly at the end of life, not those who yet have years of life, love and care ahead of them. By supporting this amendment, members will be protecting the integrity of the bill purpose and protecting vulnerable people from a quite profound expansion of what assisted suicide could mean in Scotland. I believe that we cannot agree on this limit if we cannot even confine assisted suicide to those imminently dying, then we must ask ourselves what kind of law are we truly making. In regard to 144, Convener, as I said, there is an alarmingly broad definition. I have written to the presiding officer and I've written to yourself in regard to, I think, some legal issues around this, and I'm awaiting responses from both of you. But as it is written at the moment, the door for people who have many years, decades of life ahead for them is for assisted suicide. Again, as I said, this is not what people hear when they hear the phrase assisted suicide. They think of someone in the final stages of terminal illness, not someone who is living with mental illness, disability or poverty. And yet, as written, the bill risks crossing that line. It risks sending a message that someone like myself, who is struggling with disability, could be open to assisted suicide. It opens those who are struggling with disadvantage or despair, again, to that. There is a profound moral error and a betrayal of the very people who need our care and our solidarity. This amendment seeks to put this right. It makes clear that a person cannot be deemed eligible for assisted suicide if their primary reason for seeking it is a non-terminal condition, such as an eating disorder, an intellectual disability, a mood, anxiety disorder, receipt of disability benefits, loneliness, financial hardship or unsuitable housing. At the same time, it recognises that people may live with these conditions alongside a genuine terminal illness. It therefore does not exclude eligibility automatically. It only requires that the driving cause of the request is truly terminal. And again, we heard at stage one from members across the chamber that that is what we were seeking to do. Again, this is not about narrowing choice, it's about protecting meaning and perhaps most importantly, protecting the most vulnerable in our society. It ensures that assisted suicide is not even inadvertently offered as a substitute for care, for community or for hope. If the state begins to respond to suffering not with support but with death, we will have crossed a line that we all want to be part of, which is a compassionate society, and I believe we shouldn't cross. This amendment asks us to hold that line with clarity, with conscience and with compassion. Thank you, Convener.
Thank you.
And I move formally 146.
Thank you, Mr. Bell.
145.
143.
143.
143.
Sorry, bingo time.
Can I point out to committee that if Amendment 143 is agreed to, I cannot call Amendments 4 and 144 due to preemption, and if Amendment 26 is agreed to, I cannot call Amendment 84 and Amendment 222 in the group eligibility to be provided with assistance due to preemption. Daniel Johnson to speak to Amendment 4 and other amendments in the group.
Thank you very much, Convener. And I think I'd say at the outset I very broadly agree with much of what Jeremy Balfour has just set out. To my mind, this debate has been marked by two substantial features, both for those advocating for this bill and those speaking against it. I think that we all want to provide dignity and empowerment for those who are in the final stages of their life, who may well be suffering from conditions and diseases that leave them in an intolerable situation. But I think, on the other hand, we also want to ensure that we don't bring about a culture whereby people feel under pressure, or that there is an expectation that they end their life in in certain circumstances, particularly when those circumstances might involve things such as mental illness, disability, and other such issues, just as Jeremy Balfour has set out. And that's why I think the definition is so important. And I understand that definitions are always difficult, and I understand the reasons why the definition was arrived at. But to my mind, the key point is that this must be only used when death is imminent and expected. You know, if I were to put it somewhat glibly, in a sense, we all have a terminal and progressive condition. And in terms of kind of the immediateness of that is a relative matter, which is why I think putting some sort of time boundary on that understanding is important. Not just so for clarity, but also to prevent judicial expansion, which I think is an issue that we've all been very concerned about based on the situations in other countries. Now, I think there is an inherent issue with time limits, which is the accuracy and how effectively they can be made. But I think the point isn't necessarily about the accuracy of a prognosis. It's actually about the clarity, about the immediacy of the likelihood of death as an outcome. And that can be a reasonable expectation. So by putting in a time boundary, I think it is about putting in absolute clarity that immediacy of the likelihood of death, that isn't counted in years or decades, but it is counted in weeks and months. Now, I know Jeremy Balfour's 143 sets that as 3 months. I have to say I think that's probably too short. I think there does become an issue if we're only leaving these decisions to be made at when death is very proximate. I think that perhaps precludes people from making a decision as calmly and as informed as they could. But I think 3 months would be better than no time limit. So if my amendment is preempted, I will understand. But I think, whether it's 3 months that the committee decides or 6 months, we certainly do need that time limitation to set very clearly that point about the imminence and the likelihood of death. Thank you.
Thank you, Mr Johnson. Liam MacArthur to speak to Amendment 24 and other amendments in the group.
Thank you very much. Good morning, Convener. Can I also thank all members who've lodged amendments to this bill at stage 2. I think the breadth of those amendments will allow most of the substantive issues that we wrestled with at stage 1 and that the committee wrestled with at stage 1 to be debated at stage 2, and that is the very purpose of this process. Can I thank Jeremy Balfour and Daniel Johnson for setting out the rationale for their amendments, and in a sense there were much in what they said with which I would agree. I think we see in other jurisdictions that it is very much at the end of life that people are accessing this choice, but I understand why we're having this debate. Maybe before I go on to touch on those amendments that have been spoken to, I'll first address my own. My Amendment 24 clarifies, for the avoidance of any doubt, that a person is not to be considered as meeting the definition of terminal illness as set out in Section 2 of the bill only because they have a disability or a mental disorder or both. This does not, however, prevent a person meeting the requirements set out in Section 2 from being regarded as a terminally ill person. Amendment 26 is consequential and tidies up drafting. I noted the concerns raised at stage 1 about the potential risk of a person with a disability or a mental disorder being assessed as meeting the definition of terminal illness set out in Section 2. I'm clear that the bill, supported by its accompanying documents, does not permit a person to be assessed as being terminally ill for the purposes of the bill only because they have a disability, mental disorder or both. However, in order to provide further reassurance of policy intent and the meaning of Section 2, and to further help inform any future guidance and practical operation of the Act, I've brought forward this amendment. It's not a change of policy, but an amendment to remove any doubt. I remain of the view that a person must not be prevented from requesting assistance to end their own life if that is their wish, because of a disability or a mental disorder, if they meet the requirements as set out in the bill and are assessed as being eligible. Turning to Jackie Bailey's Amendment 73, as this relates to the amendments I've lodged in this group, Amendment 73 and consequential Amendment 84. I think duplicate part of my Amendment 24 relating to mental disorder. However, it doesn't include the part in relation to disability. I'm very supportive, therefore, of the principle of Jackie Bailey's amendment, but ask her not to move them, and that the committee supports Amendment 24, given its application both to mental disorder and to disability. Turning to Jeremy Balfour's Amendment 143, which, as you've said, convener preempts Amendments 144 and 4. I consider that the first two parts of the amendment relating to the diagnosis of an irreversible and actively progressive disease, illness or condition, and no treatment being available that could reasonably be expected to prevent death or lead to recovery, are already provided for in Section 2. In terms of the proposal that terminal illness should be defined as a person being considered to have 3 months or less to live, as the committee heard during stage 1, there are risks in including a time frame for prognosis of death. Many who gave evidence to the committee... Of course, yes.
I'm glad to remember. I suppose this, to some extent, is a bit of a probing amendment. And 3 months. Would you recognise that within the social security legislation that this Parliament put through in the previous session, it was 6 months was the kind of definition that is the understanding to get benefits quicker if you have terminal illness? Would he want to put any time limit on this, or does he see having no limit at all if some amendment was brought back at stage 3?
Can I thank Jeremy Balfour for that, and for the clarification that the Amendment 143 is more of a probing nature. And as I say, I think it's important that we have this debate because it has been a live debate. We see in other jurisdictions, as I'll touch on shortly, that similar prognosis periods are applied. I think in relation to the social security legislation, while a prognosis period of 6 months was initially proposed, actually the view of Parliament was that because of all the practical difficulties with that, having no time frame set was more appropriate. And this was a view that many who gave evidence to the committee at stage 1 took, noting how difficult it can be for health professionals to estimate with any confidence how long a terminally ill patient has to live. And that will depend depending on the condition. And I note in the committee's stage 1 report that it concluded, on balance, the committee recognises the rationale for not including a prognostic timescale in the definition of terminal illness set out in the bill, and for arguing that it is ultimately better to leave determination of whether or not an individual meets that specific eligibility criterion to clinical judgment. I'll take an intervention from Daniel.
I'm very grateful to the member for taking ownership. Would he accept my point that in principle what one is seeking to do with a time limit is, rather than necessarily establish accurate prognosis, is actually trying to bound how immediate we're expectation the prognosis of the end of life to be? And furthermore, I mean, would he imagine that such at least time bands would have to feature within guidance in order to, otherwise do we not run the risk of having an expansion of actually how does one judge immediate if we don't put it on the face of the bill or don't put it in guidance?
I appreciate, again, the amendment from the intervention from Daniel Johnson. I think, as I say, there are other jurisdictions that operate with these prognostic periods, and issues appear to be manageable in that context. Nevertheless, I think the argument around how difficult it is to establish with any certainty the accurate time until an anticipated death is an issue that the committee heard in evidence and took the view, as I say, in its stage 1 report. Amendments...
The member take an intervention?
Yes, of course.
I thank the member for taking the intervention and listened carefully to the points. And I suppose that the point that the member has brought in his amendment around not only because someone is disabled, actually also relates to Daniel Johnson's points a moment ago about the timescale. And without a timescale, first of all, I would argue that the amendment that the member has brought is very, very difficult to determine, to separate the difference between terminal and being a disabled person? And secondly, would the member accept that in most circumstances, anyone who is terminally ill is also considered disabled, and the two things are inextricably linked?
I thank Pam Duncan-Glancy for that intervention. I don't happen to agree with that, and maybe as I go through responding to the amendments, that might become clear in terms of the rationale. Amendments 143 and 144 appear to offer alternative options. The former suggests prognosis period of 3 months, as well as my general concerns around setting prognosis period. I would add that there are no examples around the world of a 3-month prognosis timeframe. Not only would it risk, I think, eligible adults being unable to access the choice in time, but would risk, as I think Daniel Johnson quite rightly pointed out, placing pressure on them to make a hurried decision, not something I know Mr Balfour would wish to see. With Amendment 144, a 6-month period is certainly more realistic, albeit I offer the same general reservations about setting a timescale for prognosis. 144 also proposes adding, for the avoidance of doubt, a person should not be considered terminally ill if their condition can be controlled or substantially slowed down by medical intervention. I would remind colleagues, and this perhaps addresses some of what Pam Duncan-Glancy was saying, that the definition set out in the bill states that, quote, a person is terminally ill if they have an advanced and progressive disease, illness or condition from which they are unable to recover and that can reasonably be expected to cause their premature death. I remain of the view that the definition of terminal illness as set out in the bill is appropriate and captures the appropriate cohort.
Would the member take an intervention?
I'm just going to make a little more progress, Ms Duncan-Glancy. Adding terms like substantially slowed down, I think, is only likely to add to confusion. In relation to the for avoidance of doubt provision that a person is not terminally ill if their illness is a consequence of voluntarily stopping eating and drinking, whilst I'm sympathetic, again, I believe this is already covered in the existing definition. Indeed, it's not something that was raised with the committee at stage 1. Turning to Daniel Johnson's Amendment 4, which similarly seeks to define terminal illness by reference to a 6-month time period. I know from my own discussions with Daniel Johnson that he was keen to open up a debate on this and ensure that happens, and I think he's been successful in that regard. As I've said, in other jurisdictions we see operating with prognosis periods generally of 6 months, albeit that often there are slightly longer prognosis periods for neurological conditions. So it's entirely right we're having this discussion. I've set out my concerns around how this might work in practice, but I'm interested to hear the debate on this and where Parliament eventually lands. I'm happy to work with colleagues ahead of stage 3 on workable amendments that might deliver this. But as I say, I think it was important to put on record why I opted for the approach I took in the bill. I think it's consistent with decisions that Parliament has taken previously in similar issues. But I'll listen to what colleagues have to say, and as I say, I'm open to having further discussions about this. Thank you, Convener.
Thank you, Mr MacArthur. Jackie Bailey to speak to Amendment 73 and other amendments in the group.
Thank you very much, Convener. Amendments 73 and 84, which is a consequential amendment, are to make clear that a person is not considered terminally ill solely because they have a mental disorder. This amendment reflects the position of the Royal College of Psychiatrists in Scotland, that mental disorders such as anorexia nervosa should not be classified as terminal conditions under the bill. It provides clarity and reassurance that the bill does not open the door to assisted dying for individuals whose suffering arises from mental illness alone. I believe that this safeguard is vital to prevent misinterpretation and to uphold the integrity of the bill's intent, which is focused on those with a qualifying terminal physical illness. I, of course, heard Liam MacArthur's earlier comments, and as Amendment 24 is captured in the intent, captures the intent of my amendment in Amendment 24, I won't be moving Amendment 73. Thank you, Convener.
Thank you, Ms Bailey. Sandesh Gohani.
Thank you, Convener. Thank you, Convener. And a declaration of interest as a practising NHS GP and chair of the Medical Advisory Group. I think there's a number of things that I would like to say regarding this. Turning to Jeremy Balfour, I think that we should be cognizant here in Parliament that it is not up to us to tell people what meaningful life is. And it is not up to us to tell people who are living their life what quality of life means, because it is different for everyone. One person's quality of life is not the same as another's. And if somebody feels that their quality of life is so bad and they are not getting what they need and they would like to go through the assisted dying process, we shouldn't be there saying no, because that's not quite right. You could still live a little bit longer, even though you are very unhappy with the way and the quality of life that you have.
Would the member take an intervention on this point?
Yes, I would.
I thank the member for taking the intervention, and I understand the member's background in this area, and so I know that he'll be aware of all of the research that also shows that significantly the difference between non-disabled people's opinion on disabled people's quality of life and disabled people's own opinion of their quality of life differs hugely, and that difference means that this bill could pose a risk.
Well, I mean, the member has the opportunity to put an amendment in to say that people with disabilities can't access assisted dying. Now, I wouldn't support that amendment because I think that the individual, disabled or not, gets to make a decision upon their own quality of life and make a decision upon how they feel they want their life to continue, or if they are diagnosed with a terminal illness, to say, actually, what's happened to me and the issues that this terminal illness has created is not something I'm prepared to continue with. And that could be at any stage. Now, yes, I would.
I'm just interested to explore this a wee bit, because are you saying if someone comes and says, my life is no longer meaningful because I have been diagnosed with something, even if that person has X number of years to live, possibly, so take, for example, MND. MND is a cruel, horrible disease, but the diagnosis can be very short, or you can end up with a Stephen Hawking situation where someone lives for 40 years. So if someone is diagnosed with MND, and they say after day 2 of that diagnosis, my life is no longer meaningful, they would be open to be allowed assisted suicide if the bill goes ahead.
Well, I'd like to start by saying this is not assisted suicide, Mr Balfour. This is assisted dying, as the bill has put, and you've said multiple times assisted suicide, and I know that's a way of being very emotive, but that is, I think, not correct. Also, if somebody is diagnosed with motor neuron disease, we do not know what stage they are diagnosed at. They could be diagnosed at a critically horrible stage where they are struggling to breathe, and it's a late diagnosis. And so day 2 of that diagnosis is very different to a diagnosis that is made when you are right at the start of that journey. And so I think that it's important that we, as parliamentarians, don't tell the people what meaningful life is. I will.
I'm very grateful. I think he's right to point to the importance of autonomy, but we also agree that actually the safeguards within the provisions of this bill would require discussions to take place around the prognosis, around the other alternative treatment and care options that may be available, to understand the rationale, the reason why an individual had come to that decision of making a request. Safeguards that aren't in place at the moment, and where we see suicide rates amongst the terminally ill running at twice and more the national average, we've got to question whether or not having the safeguards in relation to this bill will provide protections that aren't there at the moment. And in a sense, I don't see any proposals coming forward where we see them applied more routinely. That having those open discussions is far more supportive of those who may be vulnerable and may need assistance in whatever form.
I would agree with that. I would go as far as saying that that was literally the next thing I was about to say. But absolutely, I do agree with everything that has just been said. I cannot support a 3-month. I think that is far too short. I am sympathetic to Mr Johnson and saying at 6 months, but I don't think that I will be supporting that, given that I feel that it's up to the individual to make their decision. And I do hope that we can agree with 24 and take forward this change in definition. I would agree with Jackie Bailey as well, but it's all in 24.
Thank you. Patrick Harvey.
Thank you, Convener. Firstly, briefly in relation to the amendments from Liam MacArthur and Jackie Bailey, I agree with Liam MacArthur that the meaning that's captured in these amendments is already included in the bill, but there's clearly a desire for some additional clarity, and I don't have a problem with that. I think it's correct that Liam MacArthur's formulation is slightly preferable, so I'll be supporting that. In relation to the specific argument about a prognosis, part of my worry here is that we end up with an unbearable pressure on clinicians who are making a judgment, and that judgment may be a matter of fine balance, as well as the potential risk that individuals who are making a request themselves could, in certain circumstances, be subject to challenge, that their ability to access the rights that the bill sets out could be subject to challenge. If we were living in a world in which prognosis was a simple calculation and it was either correct or incorrect, then I think a time limit of this kind would be workable. We're not living in that kind of world. And the kind of judgments that are required here to give a prognosis are not precise. And I think one of the things that we should be keen to avoid, if this bill passes and becomes legislation, we should be keen to avoid individuals, either professionals involved in this process or people who are seeking to access the right to seek assistance, ending up with their circumstances being subject to challenge and query, and for their rights to be essentially blocked by those seeking to challenge judgments that have been made in that way, judgments which by definition can't be precise. Give way.
Yeah, I understand that, and I think I don't think you move an amendment. You're proposing a time boundary without thinking about those things. However, on the other hand, I think the principle here is that we're wanting this to be exercised by people whose death is imminent, and I think Jeremy Balfour put that in terms of that's weeks or months. How do we capture that unless we put that? And if so, is there a way that we could be found to capture this where we're not setting an absolute threshold? It is literally just trying to capture that sense that this is something to be exercised by people whose death is very, very likely to be in the coming weeks and months, rather than it being used by people whose death might be years away.
I think the most important thing that we should bear in mind is that is how people are overwhelmingly likely to use the right to seek assistance. I think the idea of somebody 2 days after a diagnosis seeking assistance and saying, I want help to end my life, I think that's a little bit of a straw man argument. I think it's a highly unlikely scenario for somebody to be in that situation after 2 days. And as Liam MacArthur says, there are a range of other safeguards, discussions, conversations that will have to happen with the patient and with other professionals, some of which are likely to be strengthened as we debate other groups within the amendments that are presented at stage 2, which will ensure that those conversations happen in a sensitive and understanding manner. I think principally the decision and the judgment needs to be driven by the individual. This is about giving people a degree of control. So I'm not convinced. I think the committee, I wasn't, as the member may be aware, I wasn't on the committee for the stage 1 inquiry. I've joined the committee since, but I think the committee got the judgment right in its stage 1 report in suggesting that a time-bound prognosis should not be required. So I won't be supporting those amendments.
Elena Whittam.
And from the outset, I would like to state my position that I support Liam MacArthur's Amendment 24, because I think that will allow us to have some more safeguarding round about the definition of terminal illness. I think in countries where that type of definition is applied, we do see, as Patrick Harvey just set out, that those who are seeking an assisted death do so at the later stages of a terminal illness. If I turn to Amendment 143 that Mr Balfour has said is more a probing amendment in nature, I do feel that with such a short prognosis of 3 months being used, we actually will put people who are terminally ill in a really difficult position of making a hurried decision rather than actually being able to take time to consider all of their circumstances. When it comes to Daniel Johnson's amendment surrounding 6 months prognosis, I feel that I would as well defer to the committee stage 1 report, which set out our understanding of why a prognostic timeframe can be particularly difficult, although I do understand members' desires to explore that issue. At this stage, I would not be supportive of that. That's not to say that I wouldn't change that position as we go forward in the debate. But I do think that if we look to clinicians trying to make those decisions in terms of access to benefits, sometimes those clinicians do feel under undue pressure to make an assessment of a prognostic timeframe, and I think that that also can lead people into a situation where there isn't a clear prognosis, but they're actually given a time limit that might not be the realistic time limit. So I think we're starting to funnel people down a path. So
would the member take an intervention on that point?
Yep.
I thank the member for taking that intervention, and I recognise the member's commitment and support for the bill. Can I ask the member what she considers would be the difference then between a person living as a disabled person and a terminally ill person if there is no time limit?
I think we've already heard from Liam MacArthur about the differences there. I agree with yourself that people who are terminally ill, by definition, will probably be considered to be disabled as well. But if we look at the protections that Liam MacArthur has placed within his Amendment 24, excluding people solely who have a disability and excluding people who have a mental health condition, I think that that starts for us to put even further safeguards around the argument. I think if we think to stage 1 as well, we heard from clinicians and practitioners from Australia, and they specifically warned us around about the limitations and the difficulties of that 6 months prognostic timeframe, which specifically excluded some people who had neurological conditions as set out by Liam MacArthur. Thank you.
Bob Doris.
Thank you, Convener. I'm minded that Eleanor Whittam said there that she's not minded to support a 6 months prognosis at this stage, but as the debate goes on, she could be persuaded otherwise. I should point out that the next group on eligibility gives her the and criteria gives the opportunity to do just that, because there's an amendment in the following group which will also put in a 6 month prognosis. I wanted to draw members' attention to that because there are 2 ways of doing this, and they're not mutually exclusive. Daniel Johnson's amendment number 4 changed the definition of terminal illness, and there's merit in that. But there's also, and I won't go on because I'm obviously the next group convener to talk about my amendment, is what we can do is we can change the qualifying criteria, which is what my amendments in the subsequent group would seek to do. But what I thought I should put on the record for the purpose of the debate in amendment number 4 in this group is the policy memorandum that Liam MacArthur set out in relation to his bill. And that states at para 32, page 8, it says, "It is not the intention that people suffering from a progressive disease, illness or condition which is not at an advanced state but may be expected to cause their death, but which they may live with for many months or years, would be able to access assisted dying." My view would be, Mr MacArthur, that seeks to strike a balance, but that balance does not appear on the face of the bill. And what amendment number 4 in the name of Daniel Johnson seeks to do is strike that balance on the face of the bill. And there's a disconnect between the policy memorandum as set out accompanying the bill and what is on the face of the bill. I just wanted to draw attention to that just now, Convener, and I'll say more in my group of amendments during the next debate. Thank you.
Thank you, Mr Doris. Jeremy Balfour to wind up. Press or withdraw Amendment 143, and I remind members that if Amendment 143 is agreed to, I cannot call Amendments 4 and 144 due to pre-consent.
Thank you, Committee. I think this has been a really helpful debate, but I think it's also raised probably more concerns for me in regard to some of the contributions made by members so far in regard to this. I mean, I think there are some contradictions in what we are hearing in regard to this. If we accept prognosis is flawed, how can we ever offer assisted suicide? Because prognosis in itself is open. And I understand it is difficult for general practitioners and other doctors to be able to give people accurate diagnoses. Absolutely.
I hear what Jeremy Walker's saying in relation to the prognosis period, but I think that uncertainty exists. I think you would find few, if any, health professionals who would not acknowledge it. But it is a factor in decisions that are taken about many types of treatment at the moment that we seem comfortable allowing medical health professionals to use their best judgment in coming to a decision. I think the point that Patrick Harvey was making, though, is that placing further undue pressure on them to come up with an accurate time frame of diagnosis, which is particularly challenging in some conditions, is not in the interest of the health professionals, but nor is it in the interest of the patients who may be vulnerable and may have questions about what the options are that are available to them.
I mean, I do accept Mr McArthur, and I'm sure Mr McArthur has spoken to many within the medical profession who do feel very uncomfortable by this, because we are going to be asked to make decisions. Now, at the moment, in regard to prognosis, you're making conditions about what future treatment you might be wanting to have, rather than saying to somebody, do you want to end your life? And I think that's a very different position to put general practitioners. Are you? Yes, yeah, you just haven't just finished. Put general practitioners. Now, you know, and many know my older brother is a GP, and he tells me the story that many years ago somebody came into his surgery, he did the usual test, did the usual things, and the person said, how long do I have to live? And he said, well, probably 6 to 8 months. And last week he was still playing golf with him. So this is very open, and I understand that it is very difficult to put time limits on it. But we are having to make law, not just for the next 2 or 3 years, but we are having to make law for the future. And unless I think we have clear interpretation and clear things on the face of the bill, we are open to judicial creep on this. And that is a concern. I'm
very grateful to Jeremy Balfour for giving way. I wonder if he might agree with me. Well, I understand the contention that the precise prognosis is very difficult and is a matter of judgment. But the reverse is also true, is that we're actually asking medical practitioners to interpret what we mean by the definition as it currently stands in terms of terminal and progressive. And actually, without putting it on the face of the bill, we're leaving that open to interpretation either by practitioners or by the people that we ask to draw regulation and guidance. In a sense, we're not avoiding that decision. We're simply pushing it to different places and potentially leaving it more open. So I understand that prognosis is not precise, but actually pretending it doesn't. And I wonder if the member might agree with me. I am concerned by some of the notions this morning that actually this is something that could be exercised by people who may have years to live. Without any attempt to define immediacy, and I understand that time may be an imperfect way of defining immediacy, but it is a defined way of defining immediacy. We potentially run into real risks of exactly the expansion that he just set out.
I absolutely agree, and I think that was actually going to take on to me, because in the contribution of Mr Sanders, the meaningful of life, is my life meaningful or not, he does seem to say in his speech that if I go with a diagnosis, and it's an early diagnosis, but I take the view that I want, that my life is not meaningful anymore, then the process can start now, except you've got to go through the discussions and you've got to have all that. But I am deeply worried that as a society we are saying that to somebody, with the appropriate treatment, you can have years to live, but we will open that door for you to do that. I think the disabled community are going to be very, very concerned by what we have heard this morning from some members of this committee. And we are opening the door in maybe not next year or the year after, but in years down the line, where disabled people are going to face themselves under extreme pressure from society in regard to doing this. I, on reflection, think that Daniel Johnson's amendment around the 6-month one is the appropriate one for us to look at. And so for that reason, Convener, I would ask them to support Daniel Johnson ones, and I seek to withdraw 143.
Thank you, Mr Balfour. Does any member object to Mr Balfour withdrawing Amendment 143? No. Okay. So I call Amendment 4 in the name of Daniel Johnson, already debated, with Amendment 143. Daniel Johnson to move or not move?
Move.
The question is that Amendment 4 be agreed to. Are we all agreed?
No. Yes.
We are not agreed, and there will be a division. Those in favour of Amendment 4, please raise your hand. Those against? And abstentions? The results on the vote on Amendment 4, 2 for, 7 against and 1 abstention. The amendment is therefore not agreed to. I call on Amendment 144 in the name of Jeremy Balfour, already debated, with Amendment 143. Jeremy Balfour to move or not move?
Move.
The question is that Amendment 144 be agreed to. Are we all agreed? No. We are not agreed, and there will be a division. Those for Amendment 144? Those against? And abstentions? The results of the division on Amendment 144 are no votes for, 10 votes against and no abstentions, and the amendment is disagreed to. I call amendment in the name of Liam MacArthur, already debated, with Amendment 143. Liam MacArthur to move or not move?
I move Amendment 24, Convener.
Thank you. The question is that Amendment 24 be agreed to. Are we all agreed?
Yes.
The committee is agreed. I call on Amendment 73 in the name of Jackie Bailey, already debated, with Amendment 143. Jackie Bailey to move or not move?
Not moved.
The question is that Section 2 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 83 in the name of Bob Doris, grouped with amendments as shown in the groupings. I remind members that Amendment 222 is preempted by Amendment 26, previously debated in the group definition of terminal illness. I point out that the following amendments are direct alternatives. Amendment 2 and 152, Amendment 3 and 168, Amendment 1 and 215. For each pair, both amendments can be moved and decided on. The text of whichever is the last agreed to is what will appear in the bill. Bob Doris to move Amendment 83 and to speak to all amendments in the group.
Thank you, Convener. My Amendment 83, which I now move, and consequential amendments 97, 108 and 119 more clearly and tightly define the population of people who might potentially be deemed eligible for assisted dying and brings the definition closer to the stated policy intention of the bill. The definition of terminal illness used in the bill itself is imprecise, something that I believe has been well illustrated in the first grouping. Key terms in the definition, such as advanced and progressive, don't have accepted standard definitions. There are multiple ways to define premature mortality. Using the definition in the bill to determine eligibility for assisted dying is therefore likely to result in a lack of clarity for the public and for medical practitioners tasked with assessing eligibility. We've already heard from members today about the challenge that medical professionals will have, irrespective of what shape this bill takes, should it eventually come onto the statute book. That combination of an imprecise definition and the application of individual judgment of the assessing medical practitioner will likely lead to inconsistencies in who is deemed eligible. The policy memorandum, which I've already referred to, and I'll do so again, states it is not the intention that people suffering from a progressive disease, illness and condition, which is not at an advanced state, but may be expected to cause their death, but which they may live with for many months and years, would be able to access assisted dying. The definition in the bill is very different from the policy memorandum, and I said in the last grouping I believe there's a disconnect there. The current definition is not an effective way to identify a narrow group of people who are near the end of their life. As drafted, the definition would likely include some people who would otherwise live for a considerable period. The definition in the bill is not precise enough, which will lead to confusion and a variation in interpretation. This could mean that people with years to live are deemed eligible. I think that's pretty clear, which is at odds with the policy memorandum which I have read out. My amendments would qualify the definition in section 2 by adding an additional clause to section 3 on eligibility. Now, that is a bit different from Daniel Johnson's amendment in the last group, because we're not creating a new definition technically of terminal illness, but what we're saying is there's additional criteria to access assisted dying, and that's a variance from the amendment we looked at and the committee didn't agree to in the last group. 31D would have... Yes, of course.
Given we've already spoke about difficulty, so I won't repeat that, but if somebody has been diagnosed with a condition and they are really struggling to breathe and they are having interminable anxiety and they are really suffering and there's nothing that can be done for them from a palliative point of view to alleviate that, and they've decided at that stage that they have no quality of life and they really want to access assisted dying, without a 6-month prognosis, if they had, say, we thought maybe a year left or whatever, that person we are leaving to suffer. And I wonder what Mr Doris would say to that individual.
I think what I would say to any individual, those who are very supportive of Mr MacArthur's intentions with this legislation, others who are deeply concerned, is that this Parliament needs to make legislation for everyone in society, and whether this law goes onto the statute books or not, there'll be many people that are deeply disappointed, worried and concerned. And what yourselves as a committee must do, Mr Gulhani, and I don't envy your challenge here, and what we as a Parliament must do is take an on-balance approach for what the correct legislative position is in relation to that. There are no easy answers, and I don't pretend that there are. 31D would have the effect that a person is only eligible to be lawfully provided with assistance to end their own life if they have an expected prognosis of 6 months or less. Now, as we've heard, I don't pretend either that any of this is easy, and there's also clearly challenges regarding a time frame for any prognosis. However, I firmly believe that having a time frame is preferable to leaving the matter completely open-ended. Those who believe the yes, of course.
I'm very grateful to Bob Doris for giving. I wonder if you agree with me. Is that there's 2 points here. I think one is the principle, and one is actually the technical drafting. And the principle here is, as he sets out, points out that the policy memorandum does seem to suggest that this is about providing a possibility to people where death is very near or imminent. And that is different to the technicality about how you capture that. But surely one thing that I think is important to establish this morning is, do we want to try and capture that immediacy on the face of the bill, or are we leaving that to further regulation and guidance? Does he agree with me that while even if the committee rejects the technicalities of what's been drafted, we do need some understanding about whether people accept that principle? I wonder if he agrees with me on that point.
I would agree with Mr Johnson. I was about to make quite a similar point. What I would say is those who believe the definition and eligibility needs to be refined further will hopefully back my Amendment 83 and its consequential amendments within the group and look to work ahead of Stage 3 to do just that, to refine it further. But I think in refining that definition or eligibility criteria, it's only right that we do so from a position of greater and not fewer safeguards. The only other thing I would say in relation to my set of amendments is in the earlier group it was mentioned that Social Security Scotland has taken that 6-month prognosis away in relation to fast-tracking benefits. What I would say is I think that is, by and large, quite significantly different. It was for fast-tracking, it gave a highest rate award, it made sure there was no reviews, and it could backdate up to 26 weeks from the application date to get as much money into people's pockets as quickly as they can in a non-stigmatised way to support them with their life. Whereas this bill is about assisting people to die. So I think there is a very different set of circumstances in relation to that 6-month rule, and I think that's important to put on the record. Regarding other amendments in this section, can I touch on issues of palliative care with Rhoda Grant's Amendment 25 and Brian Whittle's Amendment 145, and social care such as Patrick Glancy's Amendment 219. I look at similar issues in groupings later on assessment of a terminally ill adult, which I hope committee members will support then, but more generally I would contend that enhancing, as these members I think seek to do, enhancing safeguards in such ways are desirable, and I look forward to hearing the contribution of colleagues.
Thank you, Mr Doris. Brian Whittle to speak to Amendment 145 and other amendments in the group.
Thank you very much, Convener. And can I start? I've been listening, obviously very intently to other members speaking to earlier amendments. And I think one of the concerns that relates to my amendments I'm just about to come on to is this definition of quality of life. And I think quality of life is a moving feast. So one interpretation of a quality of life at a moment in time doesn't necessarily mean that quality of life will remain poor. And I have to say, I have a relative who would suggest that their quality of life had been extremely poor and would have wanted to end their own life at that time. And 15 years later, that person is a grandparent and having a great quality of life. So I'm really concerned when we start to talk about quality of life that an individual's quality of life or perception of their quality of life at a moment in time is something that we consider relevant to accessing assisted dying. So, and related to that, my Amendment 145 is around access to palliative care and the inequality of access to palliative care and the ability of palliative care to improve somebody's quality of life towards their end of life. And we know in this country that access to palliative care is incredibly unequal, especially around the more deprived areas. And my concern is that if we don't put some sort of safeguard in place around what we define as a basic right to a basic level of palliative care, that assisted dying becomes a preferred option to patients because of that lack of suitable and deliverable palliative care. Of course.
Thank you. I feel that the individual has a right to say no. So at the moment, I would love every patient of mine that has a terminal illness or a pain or a problem that needs palliative care to be able to access palliative care. I think I love the people who do palliative care. They do great work. But lots of patients say, no, I don't want that. And it should be up to that individual to make the choice. And I wonder, I'm very sympathetic to your amendment, and I wonder if you were to change it so that it is discussed with the individual, and if they would like one, then absolutely I think they should have one. But if they say no, despite best practice, it is their right to do so.
Well, I agree with you. They should have the right to say no to palliative care, but to be able to say no to palliative care has to be an offer in the first place. I think that's really what I'm trying to put here. If somebody wants to decides that assisted dying is the route they want to go down, they should be able to say no to palliative care, and you can only say no to palliative care if it is available. So what Amendment 145 does is allows the Scottish Government to make a definition of what they mean by the standards of palliative care, or the minimum standards of palliative care for those who want to access assisted dying. I don't see how we can do without that, because it becomes an incredibly unequal bill if there are those who can and those who can't. And we need to have a fully costed palliative care support plan that ensures that that is deliverable. And I know I have engaged quite extensively with the third sector on this amendment, and understand they are hesitant sometimes that they become a barrier to access of palliative care. But I would say that access to an acceptable level of deliverable palliative care is not just important but crucial in considering this bill. 207 is just a consequential to 145. Convener.
Thank you, Mr Whittle. Rhoda Grant to speak to Amendment 25 and other amendments in the group.
Thank you, Convener. I want to speak to my amendments 25, 30 and 31. Amendment 25 ensures that to be eligible for assisted dying, a person must first have an anticipatory care plan that includes palliative care in it. Amendment 30 and 31 are consequential amendments. 30 includes that in this a statement to that effect in the assessment statement, and Amendment 31 excuse me, includes a statement to that effect in the second declaration. I don't support the bill, and I think it's important to put that on record, but I have real concerns that should it become law, that people will opt for assisted dying due to a fear of having very little support at the end of their lives. This amendment ensures that they have an anticipatory care plan in place, which includes a palliative care plan, and it empowers people coming towards the end of their lives to plan ahead and to ensure that they have control over the care they will receive at the end of their lives. If they go ahead with assisted dying, at the very least they will have had all options explained to them and laid out in detail. And I also believe that these amendments would ensure that those who fear for the future and what may lie ahead will have the information about that and have input to the care they receive. And it means that every decision is informed, and no one should feel pressure to access assisted dying for fear of how they may die without the full knowledge of an anticipatory care plan. I will. I just finished, but I will take it.
I didn't want to interrupt your flow. There's a very low uptake of anticipatory care plans in the general public, and I would love everyone to have an anticipatory care plan, a power of attorney in place, and a will in place. That would be great for everyone to do and good practice for everyone. Again, it does seem like it's an individual's right to choose not to do that, no matter how good it would be for them. And I wonder if Rhoda Grant agrees that in Section 7.1 Part 3, that there's a duty on registered medical professionals during the first declaration to discuss any palliative or other care plan available to them. And so forcing them into something, despite having a discussion about what is available and what they could have, might be a barrier.
So I see this as a better protection. I have personal knowledge of looking at end-of-life care for relatives and the like, and indeed constituents who are in that position representing them. I know it's incredibly difficult to get a proper palliative care plan in place. I've had constituents who just simply can't get that, all despite crying out for it and wanting it in place. I also know through personal experience that getting that to come together, hang together, is very, very difficult. And that, at the end of life, I think would fear people into what was ahead of them. So at least if it's laid out and they know that that's what they are going to get towards the end of their life, they can make an informed decision about what they want to do. At the moment, a right to palliative care does not exist. And at least this would provide that for people towards the end of life.
Thank you, Ms Grant. Pam Duncan-Glancy to speak to Amendment 219 and other amendments in the group.
Thank you, Convener. And it will come as no surprise to anyone, nor will it make any front page to say that I don't support the legislation. I think people know that. But what I do want to do is use this opportunity to try and raise some of the concerns that have been raised by disabled people and others, but also seek to strengthen the bill so that if Parliament had decided to support it, there were safeguards in the bill, and that's what I'm seeking to try to do. Amendments 219, 221 and 222 make provision about eligibility for assistance, but with an expanded definition of appropriate social care. Amendment 219 specifies that a person is eligible for assistance under the Act only if they have access to appropriate social care relevant to their terminal illness. In drafting these amendments, I had wanted the question to not be quite as narrow as relevant to their terminal illness, because I think there will be some people who might need social care which is out with the purpose, the reason that they have a terminal illness, and I was told that the bill was too narrowly drawn to be able to do that. So I don't think that this is the safest bill as it stands, and I don't think that this amendment will make it safe for disabled people, for example, who access social care on a regular basis or try to access social care on a regular basis but who are unable to get it. However, within the confines and the scope of the legislation, I think that this amendment is an important one. Amendment 221 specifies that a person is ineligible to be provided with assistance to end their own life if they've been unable to access appropriate social care relevant to their illness and or on a waiting list for such social care for a continuous period exceeding 6 weeks prior to making a request for assistance in accordance with the provisions of the Act. That's important because all of us around this table know the experience of our constituents and how difficult it is for them to access any form of social care, and indeed the points we've just been made around social care that's required during in a palliative care approach. And so I think it's very, very important that we do not create a situation in Scotland where the intolerable circumstances have arisen in someone's life for them to make an assessment of their quality of life that is such that they cannot continue because they have not been able to access a crucial aspect of independent living, which is social care. And I think these amendments are therefore essential. Amendment 224 sets out a definition of appropriate social care, which includes but is not limited to care provided in accordance with each risk category of the national eligibility criteria. Again, members around the table will be very well aware that a number of our constituents are struggling to access any social care that is literally not providing them with just about life and limb care. Most local authorities are right now operating an eligibility system that says you can only access social care if you have there is substantial risk to life as a result. And I think that we have to bear in mind that the bar between whether or not life is tolerable and whether it is intolerable cannot just be that you're at a substantial risk of dying if you don't get social care. And that's why I think that we need to consider the broadest possible definition, which is why I've brought this amendment. Again, I would stress to members across the room that even with these amendments, we are still, because of the narrow scope of the bill in terms of assisted suicide, we are only talking about people who are eligible within this. We are not, therefore, able to talk about or amend the bill to address social care in general, which is what I think is needed in order to prevent the sort of everyday ableism or internalised ableism that comes with being unable to access social care on a daily basis that can then build into this feeling that your life is intolerable. And that, again, comes into the Group 3 on coercion. It's the sort of thing that could encourage people to end their lives. And so, whilst these are narrowly drawn, I think they're important. Amendment 227 and 228 make provision about the assessment that the medical practitioner must undertake to ensure the person has been offered and provided with appropriate advice and support. When many people are diagnosed with an illness, be that illness terminal or otherwise, there is a sense of loss. I was diagnosed with my illness when I was 18 months old, too young to directly experience any sense of loss. But I know that my parents did, and I know that the people who were around my parents felt that sense of loss. And it is that we need to make sure that we are creating a society that is around people to provide them with the level of support and also signpost them to the sorts of services that could exist to make your life tolerable, even at the end. But my argument is still, particularly given the conversation we've had in the previous grouping around the timescales, my argument is still that if we do not sort some of these structures, the systemic inequality that exists around disabled people that can come from the fact that social care doesn't exist for many, many disabled people to allow them to live their life equal to others, then we are creating a circumstance where choice is not equal and we aren't taking control of our own lives. The state is taking control of our own lives and has been for decades as a disabled person because we rely so much on those systems. And so I think my amendments in this bill seek to try and operate within the constraints of the scope to try and do the best I can, but they will not address some of the issues on coercion. I'd also like briefly, Convener, if I may, to talk about the amendments where we have another opportunity, and I would encourage members to take it, to look at including a definition of 6 months. I think the arguments made previously by many, including Jeremy Balfour, Daniel Johnson and more recently in this group by Bob Doris, around the question of premature illness. I say what I'm about to say not because I'm looking for the tiniest violin in the world or not because I'm trying to pull at heartstrings, but because I'm trying to set out the real dangers with some of this, which is why I would encourage members on the committee to vote for the amendments that include a timescale. The definition of the legislation as it posed says the member decided, and this is in the policy memorandum, to focus on whether a registered practitioner considers a person to have an advanced and progressive illness. I was diagnosed with juvenile idiopathic arthritis when I was 18 months old. I'm now 44 years old, and there is not a medical practitioner in this country that would not consider my condition to be advanced and progressive. And it is not something I'm going to recover from. And that has been proven time and time again. So I meet those criteria. And yes, as a result of some of the condition that I have, my medical condition, it could cause my premature death. And so as it stands, this legislation has no protections, and I don't think it's intended to cover me, and I'm not saying this to make it sound like I do think it is, but the fact is it does. And without having the 6-month time limit, we are opening it up to any advanced and progressive condition, which I have made the point earlier about most of those people being disabled people. And I'm asking the committee to use the opportunity now to put the safeguard in for some of these amendments. People know I still think I will still have some concerns with it, but the 6-month time limit is incredibly important, without which, how do you draw the line between allowing someone like me to take my own life because things have got so intolerable because my social cares fell apart, or my house isn't accessible, or I can't get public transport, or all of the things that make life very difficult for disabled people? How do you draw the line between someone like me choosing this option and not? And so I'd encourage members, please think very, very carefully about how they vote on the 6-month amendment in this group. Thank you, Convener.
Jeremy Balfour to speak to Amendment 146 and other amendments in the group.
Thank you, Convener. And can I say I fully support the other amendments that have been discussed so far. At the heart of this bill lies an interesting assumption, and that assumption is that every individual has the capacity to make a decision about life and death. But I would argue both within law and actually within practice, this assumption is not true. Capacity is not constant. It can fluctuate with illness, medication, fear, depression, or external pressures, as we've heard from Brian Whittle and very powerfully from Pam Duncan-Glancy. And yet this bill begins with the presumption that everyone is capable of giving fully informed consent to their own death. And I think that's a slightly extraordinary presumption to make in law, and is actually quite a dangerous one as well. Because when the decision is irreversible, when it involves the deliberate ending of life, we must hold ourselves to the highest possible evidential standard. Anything less would be a profound failure of our duty to protect those whose vulnerability may be obvious, even not so obvious to themselves, but to others. And this amendment strengthens that safeguard. It reverses the default presumption an individual must be presumed not to have capacity unless it can be proven on the basis of clear evidence that they do. And it also sets a higher bar. It says it goes to beyond reasonable doubt, which is clearly understood by lawyers and by, I think, most within the public. And it defines what true capacity means in this context: a full understanding of the nature and consequences of the decision, awareness of all available care, treatment and palliative options, and the ability to communicate the decision and the reasoning behind it clearly and voluntarily. And actually what it says is actually what Mr MacArthur and others have been saying they want to be on the bill. Because as Pam Duncan-Glancy articulated very clearly, for many people with disability, if you take away their care package or you reduce their care package, life could become almost not worth living. I could imagine a situation where I had no family, the care package was cut, I couldn't get dressed in the morning. Would I want to continue living, being housebound in my pyjamas 24/7? And so that's why I think we have to think very carefully and why Pam Duncan-Glancy's amendments are so clear. This amendment, let me be clear, is not about creating obstacles. It's about ensuring integrity. It ensures that only those who truly comprehend the gravity of what they are deciding can do so. If we are to legalise on life and death, let us at least do it with humility and humanity that recognises how fragile human judgment can be and how permanent death always is. If I can move then to Amendment 147, we've had already quite a lot of discussions around the terminology and the vagueness, I believe, within it. And as I said before, that this, I believe, could lead to people who come into this who have not had the appropriate treatment. There's a real risk that we could include those suffering, particularly from anorexia nervosa, as Jackie Bailey pointed out, which is a severe and life-threatening mental illness, but one from which recovery is possible. I believe to treat such a person as terminally ill is not compassion, it is actually the opposite of that. When someone's judgment is clouded by an illness that distorts their relationship with life and death, surely our duty as a parliament and society is not to confirm that despair, but to offer hope, treatment and care. If this bill's wording allows those who can recover to access assisted suicide when it fails in its most basic moral duty to protect life when life can still be saved. This amendment would ensure that that cannot happen. It makes clear that an illness cannot be classed as terminal if it can be controlled or substantially slowed by medical intervention such that death is not reasonably expected within 6 months. It also specifies that an illness cannot be considered terminal if it is a result of voluntarily stopping eating and drinking. These are not minor technicalities. They are essential safeguards, particularly for those battling anorexia, ensuring that this Parliament does not, however unintentionally, create a legal pathway for suicide among people who could otherwise be treated, supported, restored to health, and often live very fulfilling lives. Any law that touches on life and death must draw its boundaries with precision and compassion. Absolutely.
I'm very sympathetic to his points around anorexia nervosa, and I think that we need to avoid or put safeguards to prevent that. However, I wonder if there's technical problems about the eating and drinking and voluntarily not partaking. There's a number of conditions, such as digestive conditions, where people may not be able to eat or drink and may be required to use enteral feeding or have gastric pegs and so on and so forth. And I just wonder whether or not that the way he has captured that might have unintended consequences.
If the committee, if the member is willing in principle to accept what I've said, and they are saying it is a technical drafting issue that needs to be tidied up, then I'm very happy to look at that. I would be interested to know if that is what the member's view is, or whether he is in principle opposed to the amendment, which I think is a different issue. To conclude, Convener, this amendment asks us to both protect the vulnerable, to defend hope, and to ensure that no one's darkest moment is mistaken for their final one. Thank you.
Thank you. Sandesh Gohani to speak to Amendment 2 and other amendments in the group.
Thank you. I would like to start by saying how deeply concerned I am about Jeremy Balfour's amendment. The idea of an individual being presumed to not have capacity is deeply concerning, because if you are diagnosed with a terminal condition or a very serious medical condition, am I to then say you can't make any decisions about your treatment going forwards if you are diagnosed with cancer because you don't have capacity? I need to prove you have capacity first. I think that is wrong. We cannot have a presumption that somebody can't have capacity. I think we need to have a presumption that people do have capacity, and it is convention that doctors will look at a person's capacity while speaking to them and bring to bear judgment about whether they have or not, and then can take it further forward to say, I'm concerned about the capacity this person has or hasn't got, and the other way round is deeply concerning. So I don't want to go into the other amendments. That one is one that I'd really like to speak about because it is of great concern to me. Convener, you'd like me to talk about 2 as well. This one is, I think, very simple. I think that 16 is a little bit too young, and we do have a problem, I think, in Scotland about the definition of what an adult is. I know there's another amendment coming which will change the age to 25. Now, I believe that an adult is somebody who is 18 years old. I believe that they, at that point, have the right to decide on their medical treatment. They have the right to decide to accept or refuse treatment. They have the right to go to a pub and drink legally. They have the right to smoke. They have the right to do a lot of things. They are no longer in school in the majority of cases. So I think that is, on balance, the right age to absolutely.
referring to my amendment, which would alter that to 25, which coming up a later group. And I hear what he's saying, and I just wonder whether he thinks there is a discussion to be had, because he's talking about rights. He's also, earlier on in his contribution, talked about capacity. And I think there's an increasing body of evidence about kind of cognitive development, neurodevelopment, which shows that people's attitudes and ability to make decisions, their cognitive ability, doesn't actually fully mature until the age of 25. And actually, if capacity is a central issue here, that there's at least a discussion to be had about at what age that should be set, because we absolutely do want to ensure that people are exercising this with the fullest of capacity. And would he accept that that is the sort of the parameters of this debate?
So I think capacity is something that is individual. And so if we look upon medical interventions, some 13-year-olds can make a decision based upon their particular ability to do so. It is different for everyone, and every person will be a case in point. But I think the vast majority of people at 18 do have that full capacity, and the vast majority of people at 18 are able to make their own decisions. And I said earlier as well, and I don't know if you would agree with me, but I feel that we need to start to think about, for the majority of cases, what is an adult. And yes, there is a development that goes on within a person's brain until the age of 25. But I don't believe that 25 is the right age, because there are plenty of 18-year-olds with the ability to make informed decisions. And that, I think, is the most important thing. Thank you.
Claire Baker to speak to Amendment 152 and other amendments in the group.
Thank you, Convener. I will speak to Amendment 152, which is in this group. And the amendment is asking the committee to consider the appropriate age to be included in the bill. And what I understand is that Liam MacArthur has indicated that he will support raising the age to 18. My amendment does align the bill with comparable policy, which considers the cognitive maturity of young people. The Scottish Sentencing Council, whose framework the Scottish Government accepts, states clearly that the brain does not fully mature until the age of 25. This scientific and psychological understanding guides how we treat culpability for crime, recognising that young adults may not yet possess full emotional and cognitive maturity. There are a number of different landmark ages where responsibilities and obligations are extended to young people. But if the principle of maturity at 25 is accepted when determining responsibility for wrongdoing, I am asking members to consider it should also apply when considering a decision that is far more permanent, a decision that would end one's own life. Raising the age to 25 aligns the bill with the same evidence-based understanding of brain development that already shapes our justice system. By applying an age of 16 or 18, we will be permitting individuals to make an irreversible choice during a period when their decision-making faculties are still developing. If we believe that a person under the age of 25 may not yet be fully capable of assessing long-term consequences when committing a crime, then surely we must apply that same caution when it comes to choosing to end their own life through an assisted suicide. This amendment is about ensuring consistency, protecting the vulnerable and acting with the same moral seriousness across all areas of law.
Liam MacArthur.
Thanks very much. Can I start by thanking all members for setting out the rationale for their amendments? And I think I have great sympathy with the motivation in every instance. I'm particularly grateful to those who are opposed to the bill but are seeking to strengthen it in relation here to eligibility. I haven't lodged any amendments myself, but I'll try to address those that have been lodged. I note that Amendment 222 in Pam Duncan-Glancy's name is preempted by Amendment 26 in the previous group on definition of terminal illness. Amendments 2, 3 and 1 from Sanders Gulhani are direct alternatives to Claire Baker's amendments 152, 168 and 215, and I'll return to these shortly. With regard to Bob Doris's amendments 83, 108, 119 and 97, which he gave us a spoiler alert to in the previous grouping, as I stated in relation to Group 1, I do have concerns about adding a period of life expectancy to a terminal illness definition. I'd have similar concerns should eligibility criteria requirements be amended so that someone must reasonably be expected to die within 6 months. I won't repeat what I've already said, but I note, for example, that jurisdictions such as the Australian Capital Territory, learning from other states in Australia and elsewhere, chose not to set a fixed time frame for eligibility. Instead, it requires that a person's condition be advanced, progressive and expected to cause death, focusing on the reality of end of life rather than an arbitrary time limit. We see there the evidence of who's accessing it, at what point in their prognosis they're accessing it. I think is borne out by the research that the committee heard from Professor Ben Colburn at Glasgow University, which I think should allay some of the concerns about the disproportionate vulnerability or extent to which those with a disability access this choice. In a second, Mr Doris. And I think it suggests, and I made this point, I think, in an intervention to Sandra Goldhanley earlier, I think recognising that this bill is putting in place safeguards that do not exist at the present time, both in relation to access to an assisted death, but more widely for those who are vulnerable, who may have a terminal illness, and at the moment are being left without support, without the opportunity to discuss the concerns that they have in the situation in which they find themselves. And I'm happy to take an intervention, I think, from Bob Doris. Or was it? Oh, sorry, Daniel Johnson.
First,
Bob.
Very popular this morning, Ms MacArthur. I just wanted to ask Ms MacArthur, in relation to, and I get the issues with a time frame for prognosis, would Ms MacArthur also accept there are significant issues with no time frame at all, and that advanced, progressive, unable to recover, reasonably expected to cause their premature death could all be seen to be very broad brushstroke also? So where does the member sit, I suppose, between that very open, broad brushstroke approach is defined on the face of the bill and the efforts to try and be more narrow and specific in the various amendments that we've sought today, including my own set of amendments within this group?
I don't know whether Daniel Johnson wants to make an intervention on the back of that, and I'll try and address both of them.
I mean, really, it's further to that, and I would echo the questions that Bob Doris just raised, and I'd add to it. I mean, as it stands, on the members' understanding, what would prevent someone with a decade or more to live from exercising the rights under this bill? I think really following on from the very powerful point that Pam Duncan-Glancy made.
I think we need to some extent detach ourselves from the issue as to the rationale for why somebody is seeking to make a request of this nature. It will be very individual to that individual. What we need to ensure is the safeguards protect the vulnerable. I think the safeguards allow interventions to be made that I said, as I said in the intervention to Sandis Goldhanley, aren't being made at the moment, and therefore make the situation for many with a terminal illness safer than it is at present. I acknowledge the fact that there are jurisdictions that have prognostic periods within their legislation. I acknowledge too that in many instances they've gone through a review period that has presumably satisfied legislators that whether it adds an additional safeguard or not, it's not inhibiting access amongst those who meet the eligibility criteria from accessing that choice. But as I say, I'm pointing to jurisdictions who don't have that, the reasons why they don't have prognostic periods, and the evidence of who's accessing assisted dying in those jurisdictions, which bears out the fact that it is very much those at the end of life with advanced progressive. And I think, in a second, Mr Balfour, I think that the assumption is that when someone receives a terminal diagnosis, the immediate reaction is to seek to make the choice of an assisted death in those jurisdictions. And that's simply not borne out by the evidence we see of who's accessing this, when and for what reasons. And I'll take an intervention for Jeremy Balfour.
I'm grateful. I'm just really looking for clarification here. So, in principle, if someone gets a terminal diagnosis and maybe has 10 years to live, if that, you would be, in principle, content, as the bill stands, for that individual to go through the process. I appreciate you've got to go through the safeguards, but in principle, go through that, and then for assisted suicide to take place.
Well, again, and I'd reject the reference to assisted suicide. I think we can have a debate at another stage about the difference between the mental state of somebody who's seeking to take their own life and somebody with a terminal illness who's looking to take control over that process. What I've said is as set out in the bill as it stands, this is somebody with an advanced progressive condition, and therefore, while I understand the argument for setting a prognostic time frame, and I welcome the fact that we're having this debate, I think as the committee concluded from the evidence that it took, that is problematic. So on that basis, I don't support the amendments and would urge Bob Doris not to move them. In terms of amendments 145, 25, 30, 31 and 207 from Brian Whittle and Rhoda Grant, I fully support the principle of a terminally ill adult having available information and options explained to them and having appropriate care plans in place if they wish, including palliative care where appropriate. It's why the bill in section 7.1 requires the assessing doctors to explain and discuss the person's diagnosis and prognosis, available treatment, palliative and other care options, as well as explaining and discussing the assisted dying process and the substance that will be used. It's also why I've lodged my own amendment at 29 to add to ensure that palliative care discussions include available hospice care, symptom management and psychological support. But as Sanders Golhani suggested in an intervention, I think greater use of advanced care plans would absolutely be welcome and help increase the likelihood of people having their wishes respected. But I think it's important too that those remain voluntary. So I'm not supportive of adding to eligibility criteria in the ways proposed in these amendments, including for a person to have an anticipatory care plan and or palliative care plan in place. Doing so would risk, in just a second, Mr Whittle, doing so would risk adding a barrier to a terminally ill adult otherwise being deemed eligible and being able to access assistance. That could be, for example, because the terminally ill adult does not want such a plan and or does not wish to have palliative care, which can be a matter of personal choice. And I'll take an intervention from Brian Whittle.
I'm very grateful to Mr McCarthy for taking an intervention. Surely he would accept, though, that to make the choice of not accepting palliative care, you have to have the option of palliative care in the first place. And you as well as every other member in here is aware of the inequality of access to that palliative care. And if you have two people, we talked about quality of life. Quality of life can be very enhanced by palliative care. And if you don't access palliative care, that you get much reduced quality of life. So to make a decision to access assisted dying has to be a decision of equality and equal. And if you don't have access to palliative care, then that creates a real problem with this bill.
Can I thank Mr Whittle for the intervention? I think he raises a very strong point. It's something that came through, again, very strongly through the evidence that the committee heard. The committee also heard from the witnesses involved in the process in Victoria and Australia that actually, as a result of the change of the law, the engagement with palliative care improved because of the discussions that are taking place at the moment are not taking place as routinely as they might. But ultimately, the decision about whether to have palliative care and indeed any other treatment has to rest with the individual, has to rest with the patient. So we need to address areas of palliative care where the access issues are not what they should be. That can't be addressed through this bill. But nevertheless, I think ultimately it needs to be a decision for the individual as to whether or not access palliative care or have a palliative care plan. But they absolutely need to be made aware of what the options are available in relation to palliative care, which is why I've lodged the amendment in relation to that, in Amendment 29. Sorry, Rhoda Grant.
Yeah, and just really on that point, I mean, my amendment says palliative care plan. That doesn't insist that the person take up that palliative care. It is simply a plan for palliative care. The bill discussing palliative care is something totally different. I mean, a lot of my constituents have discussions around palliative care, and quite often it is what you want to happen won't happen because we don't have the ability to do that. Whereas having the plan in place is a guarantee to somebody that that will happen. That is their choice by putting that plan in place, rather than just simply having a discussion that it's unlikely to happen for you.
I get the point that Rhoda Grant is making, and ideally one would want people to have as much advanced planning, including in terms of palliative care, as possible. But the concerns about making that part of the eligibility criteria, I think, are highly problematic for some of the reasons I've touched on, and I'll come on and hopefully address that in more detail. So making such plans part of the eligibility criteria could result in a terminally ill adult who would otherwise be eligible, but who has a short time to live, dying before such a plan could be put in place. In relation to these amendments, the Scottish Government has also highlighted the Chief Medical Officer's confirmation of a change in terminology from anticipatory care planning to future care planning, while noting, and I agree that, quote, the process of developing a future care plan should be holistic and person-led, with a focus on shared decision-making. As such, setting out that a person must have a plan in place, which must include a plan for palliative care in order for them to be eligible for an assisted death, goes strongly against this person-led ethos, given that some people may not want palliative care for a number of reasons. With regard to Pam Duncan-Glancy's amendments 219, 221, 222 and 228, I'm fully supportive of people with terminal illnesses having full access to social care. However, be concerned about adding a requirement for a person to have such care in place to meet the eligibility criteria. I don't agree that a person should be ineligible for an assisted death if they have not accessed social care or have been on a waiting list to access social care for 6 continuous months. Doing so would risk adding a barrier to a terminally ill adult otherwise being deemed eligible and being able to access assistance. With regard to Ms Duncan-Glancy's amendment 227, briefly, yes.
I thank the member for taking the intervention, and forgive me because I thought he'd got to the end of the amendments and that. I'm not sure I fully follow the argument that we shouldn't ensure social care, or indeed the previous arguments on palliative care, are offered. I don't understand why that should become a barrier, unless the member is admitting that that social care and palliative care are in such a poor state in Scotland just now that the timescales involved would be difficult and the money involved could be prohibitive.
Sorry, I thank Pam Duncan-Glancy for the intervention. I think the difficulty is making eligibility contingent on having a care plan in place or having accessed social care or accessing palliative care. That needs ultimately to be a decision for the individual. With regard to Ms Duncan-Glancy's Amendment 227, I'm supportive of people with a terminal illness having access to appropriate advice and support about living with their illness, and would urge the committee to support this amendment. In relation to Amendment 146 from Jeremy Balfour, the committee will be aware that the law in Scotland generally presumes that adults are capable of making personal decisions for themselves. The starting point, therefore, is a presumption of capacity, which can only be overturned where there's medical evidence to the contrary. This amendment appears to reverse this, with capacity to be proven, not assumed. I'm not sure Mr Balfour would support this approach in other circumstances, and I think consistency with the principles and approach we take in other areas is important, not least in reducing the risk of confusion, but also in respecting the right of individuals. That's something I know that Mr Balfour takes enormously seriously and has a strong track record in defending. Given the complexity and finality of the decision in question, 2 doctors have to be satisfied that the ability to make that decision is not affected in any way. This is one of the essential safeguards and protections in the bill. Specifically, it sets out that to have capacity to request an assisted death, the person must not be suffering from any mental disorder which might affect the making of the request and must be capable of understanding information and advice about making the request, making a decision to make the request, communicating the decision, understanding the decision and retaining memory of the decision. That the person wishing to access assisted dying fully understands the decision they are making in all its complexities is therefore a precondition under the requirements of this bill. The bill adopts the established test for capacity that doctors are currently applying from the tests set out in mental health legislation and applies this in the assisted dying context. I note that Amendments 146 and 147 appear to present alternative options. Regarding Amendment 147, I'm not persuaded that capacity should be tied to the person's reasons for seeking an assisted death as provided for in this amendment. I believe that this could muddy the waters by including subjective elements to an objective process, only risks making it difficult for health professionals to carry out assessment. It also potentially discourages open conversations between doctors and their patients. I support Amendments 1, 2 and 3 in the name of Sanders Gulhani and ask the committee to support them. I'm on record as supporting a change in the minimum age of eligibility from 16 to 18. Members will be aware of why I set the age at 16 in the bill and in the interest of time I will not rehash those.
Sorry, would the member take
I'll take a brief intervention.
So it's on the age, convener. If you look at the Scottish Sentencing Council research, areas they highlight are that young people are generally less able to exercise good judgment when making decisions. They're more vulnerable to negative influences such as peer pressure and exploitative relationships, and they may take more risks. And that research does seem relevant to the decision the committee is going to have to make on age. And I'd also say that it's 16 or 18 decisions that young people can make at that age, whether it's get married, start smoking, to start to drink alcohol, they're all reversible. They can get divorced, they can give up smoking, they can become teetotal. This is not an irreversible decision, and I would caution members to accept the 16 or 18 as the age that this is appropriate.
I thank Claire Baker. I was going to turn to Claire Baker's amendments shortly. I think the point she makes is one that I fully understand. I think it's problematic in opening up the prospect of raising the age at which we allow a whole host of things to happen and for capacity to be assumed within young adults to a level that I think we would find it difficult to justify in other areas. I think there are other ways of addressing some of the concerns that Claire Baker has raised, and I'll come to that in a second. Briefly, yes.
Just on good judgment, peer pressure and taking more risks, I was a doctor at 24. So does this mean that it is okay for me to make a decision on other people's lives, but not on my own?
But there's a point being made by Claire Baker. I mean, Sanders Gulhani's point is made. As I say, I support the raising of the age to 18 and would urge the committee to do so likewise. In terms of the age threshold proposed by Claire Baker and preempted by Daniel Johnson's earlier intervention, I'm not persuaded of the case of raising this to 25 as provided in Amendments 152, 168 and 215. In other jurisdictions with similar legislation in place, 18 is typically the age at which someone becomes eligible, and during stage 1 evidence, many of the witnesses appear to consider 18 as the appropriate age of eligibility. Claire Baker set out, I think, very clearly the thoughts of the Sentencing Council. I'm conscious too from the interactions I've had with Chas over the past few years about their concerns in relation to issues pertaining to young adults under the age of 25. But I believe that those issues are better addressed through the training that we will come on to discuss in subsequent groups, but also ensuring the involvement of relevant medical and other professionals, again, something that's contained in other amendments. So I would urge the committee, as I say, to back the amendments in the name of Sanders Gulhani and encourage Claire Baker not to press her amendments to vote. Thank you, Convener.
Thank you, Mr MacArthur. Bob Doris, to wind up and press or withdraw Amendment 83.
Thank you, Convener. It's been quite a lengthy debate. I should say during my summing up that my amendments all through this legislation were lodged in partnership with the Scottish Partnership for Palliative Care, who are the Secretariat of the Crossbit Group for Palliative Care that I convene in the Scottish Parliament, and they surveyed in detail their members. They're an umbrella organisation, and each individual organisation will have their own views on assisted dying. The partnership itself has no view on it, it's not aligned, and the amendments that's come forward in my name, they believe on balance, as a partnership, as an umbrella organisation, are reasonable safeguards to be put in place. I should also put on record, as others have, that my view on the bill is that it shouldn't proceed, but I take my responsibility as a member of the Scottish Parliament very seriously, and that irrespective of my personal view on this legislation, that I should make it as robust as possible, and that has inspired my amendments that we'll be looking at over the course of the next few weeks. I wanted to put that on the record. I don't think I'll say any more in relation to my own particular set of amendments. I think that has been quite well made in relation to the need for a prognosis with a timescale versus a completely open-ended approach. I think the member in charge of the bill is wrestling with that, as are committee members in the Parliament. I'm sure we'll return to that at stage 3. I would rather you supported my amendments here at stage 2 quite clearly. But I think it is important to put on the record in relation to palliative care support plans, anticipatory or future care plans, or a right to palliative care was mentioned, that these amendments don't directly secure any service or right. Because there is a palliative care support plan does not mean there's resource there to deliver the palliative care support plan. We heard about the anticipatory care planning, the issues Dr Gulhani mentioned in relation to that. I know very well one of the main issues with that, for example, convener, is a reluctance of family members and care staff to talk about anticipatory care planning, and there's a cultural reticence in relation to that. I think that makes all the more important that we make sure that those seeking assisted dying can make an informed choice. And if someone is seeking to go for assisted dying, there's no time to back away from someone to say, look, here's what palliative care could do for you. Let's look at this to make an informed choice. Yes, of course.
I'm very grateful for Bob Doris for taking the intervention. Both Rhoda Grant and myself have made the point quite strongly, I think, that we're not forcing people into palliative care, we're not forcing people into to take social care. But the important point is to make an informed choice, to make an even choice. It has to be available. And that's the key element here.
I think we're in danger of agreeing here, Mr Whittle. That's the point I was trying to make. I think that the caveat I would provide, Mr Whittle, is that these amendments don't guarantee any of that. They guarantee that there would be a palliative care support plan put in, offered, but whether the resource will be found to deliver that plan is another matter. It could guarantee that an anticipated care plan or a future care plan was sought to be drafted, which the individual may or may not comply with. That would tick another box, but it doesn't guarantee the delivery of anything, because the guaranteeing the delivery of palliative care as a right and others was out with the scope of this bill. And I think we'll return to that later about why this bill might not be able to provide the safeguards that some people would like to see. Of course, yes.
I wonder what your thoughts are on Section 7 of the bill, which does place a duty on registered medical professionals during the first declaration to actually discuss palliative care and any other care that may be available to that individual, which then would allow the individual to make an informed decision themselves round about any palliative care plans or future care planning that could be made. Does that not give you the safety of understanding that that will be discussed at that point, whereas tying it to eligibility criteria means that that person doesn't have the autonomy to be able to say, I don't want those plans made. And indeed, when timeframes are really short, that actually might preclude somebody from accessing the supports that are available under this bill.
I think what I would say to Eleanor Whittam is that in relation to short timescales, that brings us back to prognosis issues, which I think the bill is not. The member in charge of the bill and the committee as yet are not really compelled with a prognosis timescale and the fast tracking of all of this. I've got amendments in relation to palliative care later on where I will look at what are... I don't believe there are safeguards in the bill as it currently stands in relation to palliative care. I think having a general discussion in palliative care is not sufficient in relation to safeguards. And in a little moment, absolutely. And I think it has to be more robust than that. And I've got a series of amendments that I think would make it more robust. But I do actually agree with Eleanor Whittam that that's a really good starting point to build in some of the safeguards that I would like to see. Absolutely.
I thank Paul Dawes for taking the intervention. I mean, he will, as the chair of the cross-party group in palliative care, be aware that the debate around palliative care was nothing like as prominent as it has been since I announced my intention to introduce legislation of this type. And actually it bears out the evidence that the committee heard from witnesses in Australia that as a result of the conversations and the safeguards that are in place around assisted dying, engagement with palliative care improves. So simply asserting that in a sense there's a zero-sum game here, I think would be inappropriate and not borne out by the evidence. And also the point that Eleanor Whittam was saying is that the discussions around palliative care need to still be voluntary, and that tying this to the requirement for there to be a plan, whether it's an anticipatory care plan or a palliative care plan, runs the risk of making somebody who would be eligible under the criteria being able to access the choice that they wish.
McCarthy, I would say to Mr McCarthy respectfully that I don't agree with how that has been framed. I, in the Stage 1 debate, raised palliative care, as many other members did. I would say at the subsequent meeting of the cross-party group on palliative care, I did not see members rushing to a cross-party group to declare that their absolute support for how we expand all of this. It simply didn't happen. I think talking about assisted dying has had many members suddenly realise that maybe on a cross-party basis we should be talking openly and honestly about what much more has to happen with regards to palliative care and how it has to be resourced and the choices we have to make as a parliament and the parties within that parliament. But that has been raised because this bill has been brought forward. It should never have been thus, Mr McArthur. We should all have been interested in palliative care, irrespective of whether there's an assisted dying bill or not. The merits of palliative care stands on their own rights, irrespective of whether there's an assisted dying bill. But I do absolutely acknowledge that by talking about this issue, it's shown a light in palliative care. It doesn't take the passage of this legislation to secure additional funds for palliative care. But I do acknowledge the point that Mr McArthur wants to make. The final thing I would like to say is that I think Jeremy Balfour is trying to put in amendments at this group in relation to vulnerabilities and capacity. There is a section later on in relation to vulnerable adults where we can look more at coercion and vulnerabilities and individuals at risk that might be a more appropriate place to sit and have that conversation on a more rounded basis. But I have no other reflections to make, Convener.
Thank you. Mr Doris, are you pressing or withdrawing your amendment?
I'll be pressing it, Convener.
Thank you. The question is that Amendment 83 be agreed to. Are we all agreed? No. We are not agreed and there will be a division. Those for Amendment 83? Those against? And any abstentions? Thank you. So the result of the vote on Amendment 83 is 2 for, 7 against and 1 abstention. Therefore, the amendment is not agreed. I call Amendment 145 in the name of Brian Whittle, already debated with Amendment 83. Brian Whittle, to move or not move?
Move, please, Convener.
The question is that Amendment 145 be agreed. Are we all agreed? No. We are not agreed and there will be a division. Those in favour of Amendment 145? Those against? And any abstentions? The result of the vote on Amendment 145 is 2 for, 8 against. There were no abstentions and the amendment is therefore not agreed. I call Amendment 25 in the name of Rhoda Grant, already debated, with Amendment 83. Rhoda Grant, to move or not move?
Move.
The question is that Amendment 25 be agreed to. Are we agreed? No. We are not agreed and there will be a division. Those in agreement with Amendment 25, please indicate. Those against? Any abstentions? The result on the vote on Amendment 25 is 2 for, 8 against. There was no abstentions and the amendment is therefore not agreed. I call Amendment 219 in the name of Pam Duncan-Glancy, already debated with Amendment 83. Pam Duncan-Glancy, to move or not move?
Move, Convener.
The question is that Amendment 219 be agreed. Are we all agreed? We are not agreed and there will be a division. Those in favour of Amendment 219? Those against? Any abstentions? The result on the vote on Amendment 219 is 2 for, 8 against, and there were no abstentions. Therefore, the amendment is not agreed. I call Amendment 146 in the name of Jeremy Balfour, already debated with Amendment 83. Jeremy Balfour, to move or not move?
Not move, Convener.
I call Amendment 147 in the name of Jeremy Balfour, already debated with Amendment 83. Jeremy Balfour, to move or not move?
Move.
The question is that Amendment 147 be agreed to. Are we all agreed? No. We are not agreed and there will be a division. Those in favour of Amendment 147? Those against? Any abstentions? The result of the vote on Amendment 147 is 0 for, 10 against, and there was no abstentions. Therefore, the amendment is not agreed. And I'm going to suspend the meeting for 10 minutes for a comfort break. I call Amendment 220 in the name of Pam Duncan Glancy, grouped with amendments as shown in the groupings. I point out Amendment 12 is preempted by Amendment 88 to be debated in the group Assessments of the Terminally Ill Adult. Pam Duncan Glancy to move Amendment 220 and to speak to all amendments in the group.
Thank you, Convener. Amendments 220, 223, 237 and 238 would ensure that requests for assistance to end life under the Assisted Dying for Terminally Ill Adult Scotland Bill are entirely self-initiated by the terminally ill adult and are made without any encouragement, suggestion or inducement from medical professionals, practitioners or other professionals involved in their care. Amendment 220 is in reference to eligibility, 223 is in reference to the first declaration, and 237 is in reference to the coordinating registered medical practitioner assessment for their statement, and 238 is in reference to the independent registered medical practitioner assessment for their statement. Convener, the notion of coercion in society is one that we know that has been discussed, debated at length in other sort of jurisdictions, I suppose I'd call it, and in particular in relation to gender-based violence. It isn't easy to detect. By definition, it's difficult to detect. But nonetheless, I think it's incredibly important that when we're looking at a piece of legislation that is allowing someone to take their own life, that we ensure as best we can that the people around that person, whose job it is to support them to live, is absolutely watertight in ensuring that they are not taking part in any of the suggestion that the person may end their life. I also want to speak for a moment on the wider coercion that I spoke to at stage 1 in the debate. And I think the amendment in Stuart McMillan's name seeks to look at some of this as well around pressure and societal issues. We live in a society just now where choice for disabled people, and by definition, therefore, people who are eligible in the Act for assistance to take their own lives, are not equal. Choice is not equal. Disabled people don't have the same choices as other people. They can't get out of bed in the morning at the same whenever they decide. Somebody else often has to make that decision because it is around the timings that suit the professionals around them. Now, that isn't to critique the incredible social care professionals that support us day in, day out, but it is to recognise that there is a substantial element of other persons' control in the lives of disabled people and indeed of the lives of terminally ill people. And for reasons I've rehearsed previously, I think the two are difficult to unlink. It's also the case that we live in a society where disabled people's lives and the lives of people who have lost certain functions are not valued in the same way as the lives of people who have certain functions. We know, for example, that the incredible Paralympian Tanni Gray-Thompson, and I know she won't mind me using this example, has in herself been in a debate in the House of Lords making the case that she is someone who is incontinent, and somebody has said, I would rather die than be incontinent. And she has had to face that in the House of Lords and said, well, I lead a very, very open, enjoyable life. Everybody's understanding of what is quality of life, and we've heard this earlier from members across the room, can be quite different. But there is very, very much the understanding that disabled people's lives are often valued less than non-disabled people's lives. The loss of function, whatever that function may be, can often become something that people fear inherently. I fear it. I don't have a lot of function, but the very little function I do have, I'd be scared to lose. And that loss is something that can really be internalised. And when people around us start to think that not being able to get out of bed on your own in the morning, not being able to shower yourself, not being able to take yourself to the toilet, not being able to feed yourself is a life not worth living, that is when we get into a circumstance where people who find themselves, by definition of a terminal illness or indeed any other illness, could find themselves internalising that and considering, what is my life's worth if I can't do that? Other people don't think that is a life worth living. And that is the societal and everyday ableism that I think exists and is a real danger in the context in which we are bringing this piece of legislation in. Disabled people are less likely to work. We're more likely to live in homes that are inaccessible. Indeed, about 10,000 of us are stuck in our own homes in Scotland because we can't get in and out of them. Many disabled people, 1 in 4, can't access the palliative care that they need. High numbers of disabled people can't access social care because of the costs associated with it. High numbers of them don't access it because of recruitment crisis. Many of them don't access it because the eligibility criteria doesn't determine that they are able to access it, because we are operating in a system in Scotland where we are literally providing very, very, very life and limb care and support to a large majority of disabled people. Within that context, the notion of choice and control is very, very difficult for a disabled person. And so my amendments seek to try and take out some elements of what coercion could be. They won't be able to address all of it, and I would ask members to think very carefully about that, particularly when listening to Stuart McMillan make his argument, which I think I'm sure will be powerful, on the points around pressure and societal coercion. It is those areas that really, really worry me about this bill, because unless we can fundamentally change social care, unless we can fundamentally change healthcare, unless we fundamentally change our housing system, and unless we get to a system that does not oppress or discriminate against large swathes of society, we're bringing this bill into a very, in a very dangerous context. So the amendments I brought in this group are here to try and protect at least some small part of it. I'd have brought other amendments that do the broader aspects of what I'm talking about, but I was told they were not within the scope of the bill, and I'd ask members to reflect on that comment. But for the time being, the amendments 220, 223, 237 and 238 are amendments that I think would provide some safeguards, if not all safeguards, although not all safeguards, into this legislation, and I'd ask and I'd encourage members of the committee to support them. Thank you.
Thank you, Ms Duncan Glancy. Can you move the amendment?
Forgive me, Convener. Yes, please. I'll move the amendment.
Bob Doris to speak to the amendment, to Amendment 85 and other amendments in the group.
Thank you, Convener. My Amendment 139 and the various consequential amendments in relation to that in this group seek to address concerns over a deficiency in the current definition of coercion in the bill. Within the bill, coercion is framed as something done by a person, whereas the current professional standard demanded by the General Medical Council guidance requires practitioners to also consider other indirect coercive factors. This is considered important for the Scottish Partnership in Palliative Care to put that clearly on the face of the bill. There is broad agreement that the assessment of coercion is central to safeguards in the bill, and the definition of coercion to be used is central to the effectiveness of any assessment. The bill's own policy memorandum, which I've referenced previously, makes reference to the relevant GMC guidance as key for assessing coercion. However, the bill itself currently uses a weakened definition. I can't see any good reason as to why this accepted professional standard should be weakened in the context of a life and death decision relating to assisted dying. Therefore, my Amendment 139 and consequential amendment seeks a definition of coercion which complies with current regulatory and professional standards and be placed on the face of the bill. As a result, practitioners assessing coercion under the revised definition will be clearly directed and able to consider the wide range of factors, of coercive factors, which we know may lead some people to wish to hasten their death. Now, I'll mention one or two of those factors, but I think Pam Duncan Glancy and others in this group will illustrate very clearly what they may very well be. For example, feeling a burden on others and financial pressures that a person is under. I know from my own lived experience that older people with frailty often feel a burden. I know my mother in the last year of her life in a care home, in her more lucid moments, she had vascular dementia, would tell me, "Son, get yourself home. Why are you here? Worried about me and my own work commitments," and that my mother was a burden on me. And before that, my mother and father in the family home, dissuading me from visiting them because they thought, well, I was a busy person at my work, and what really was there for me to go down and visit them? So they had a view of themselves and a view of me that made them feel like a burden. And that's just a personal experience that I would share with the committee. Yes, of course.
Would the member reflect also that this, if it becomes an act, will be there for generations to come, and that kind of attitude can build up by not directly, but by watching TV programmes, by reading newspapers, by social media, that it may not be absolutely at the heart of what society thinks at the moment, but over a 5-10 year period, we could see that pressure build on vulnerable individuals. due to things that are reflected in society more widely?
Thank you for the intervention, Mr Balfour. Possibly, I suppose my answer would be, my general comment to the intervention would be that we have to ease burdens within society and challenge the idea of someone who has ill health or a terminal condition or old and frail being a burden in the first place, and to say that their life is valued irrespective of all of that, and that a pathway to easing that burden would not be assisted dying, but be to better support them as an equal member of society as best we can. I would note that the only amendment in this group in my name, which may be considered not to be a consequential of my Amendment 139, is Amendment 140. It adds a definition of voluntary to mean not having been coerced or pressurised, or pressured rather. The bill would otherwise be silent on what the definition of voluntary would mean. However, this definition makes it clear that an act is not voluntary if coercion or pressure is present. That is important, as on the face of the bill, the distinction is not always clear when the word voluntary is used. For instance, at Section 6 on medical practitioner assessments, at Part 2C it states that a declaration must be made voluntarily and not being coerced or pressurised. It can't be voluntary if there's coercion and pressure. Therefore, we have to define voluntary, in my view, on the bill. It is important to be clear that a person cannot act voluntary if they have been pressurised or coerced. Amendment 140, I hope, clarifies this. I have no other comments in this section. Yes.
Grateful. I didn't want to interrupt in the middle, but I am still hoping that the member could say a little more about what seemed to me to feel subjective issues in the definition, in particular about coercion, meaning having or including having been unduly influenced by a person's own belief about themselves. We're all very conscious, I think, that we're discussing a subject where people have profoundly different values in society. There will be people around this table with very different values about how we make decisions in our own lives. And legislation of this kind needs to reflect and respect the fact that people have a right to make decisions in line with their own values, not in line with the values that are imposed on them by society. Can the member tell me what is the difference between quite legitimately making a decision in a way that is reasonably influenced by my beliefs about myself, as opposed to what would now be considered coercion about being unduly influenced by my beliefs about myself? It does feel to me quite a subjective and a difficult to define area.
Thank Mr Harvey for that intervention. I suppose I would answer that in two ways. The first way actually relates, I think, to Mr Balfour's intervention earlier to myself, where someone may have be a confident, enabled individual, get a terminal diagnosis, and everything that then follows from that may lead to that person having less self-worth. It shouldn't be so, Mr Harvey, but that could happen. They could have adult family members who are giving out caring roles to look after them for their primary care needs. They may think they're a burden on those individuals, and their view of their own self-worth may be impacted on that. Now, that is myself making an anecdotal potential example, Mr Harvey, which I probably shouldn't do, because that's not the intention, actually, of this amendment. The intention of this amendment is to be consistent in how the medical profession define, and the General Medical Council, how they define coercion. So this is not my own view in relation to how coercion should be defined. There's a definition that exists. It exists in all other areas, and not to have it in this area over life and death and dying seems to be remiss. Now, I absolutely accept the point Mr Harvey's making about it would be better to understand that a bit more. And I agree with Mr Harvey, but I think I would ask the rhetorical question about why we would use the GMC definition of coercion for everything else, but not use it on assisted dying. And what my amendment simply does is make sure we're consistent in our approach to that. Convener.
Emma Harper to speak to Amendment 12 and other amendments in the group.
Thanks very much, Convener. Good morning to everybody. I've been listening carefully today and appreciate colleagues' thoughtful and respectful contributions so far. I have amendments 12 and 13 and they are directly linked. 12 allows introduction number 13. My amendment seeks to allow registered medical practitioners to consult with other health and social care professionals such as nurses, carers and social workers when assessing whether a person has made a declaration voluntarily and without coercion. And I'd like to remind colleagues that I am still a registered nurse. The proposal was informed by engagement over summer recess with constituents, medical professionals working in end-of-life and palliative care. I also met with the Royal College of Nursing over the summer and again recently, as well as the Scottish Association of Social Work. Concerns from the medical professionals were raised that non-medical professionals often have more frequent and meaningful contact with individuals nearing the end of life and may be better placed to detect subtle signs of coercion or distress. And I acknowledge what Bob Doris says regarding how persons feel like they are a burden. Originally, my amendment aimed to strengthen safeguards and promote a multidisciplinary approach, ensuring assessments are thorough and person-centred. Acknowledgement was highlighted and then made of concerns around the wording, particularly regarding the liability, responsibility and training of professionals like registered nurses to be accountable for assessing coercion, whether overt or subtle. And I am aware of the potential cost implications in this approach. My amendment, therefore, is presented as a probing amendment with a willingness to work with the member in charge ahead of stage 3 to redefine the language or change it if that should be necessary. Thank you.
Will the member take an intervention on that?
I think so, but I was finished.
Yes, if it can be brief, Ms Duncan Garnsey, as Ms Harper has just finished.
Thank you. Forgive me, Convener, I hadn't realised you were just concluding. Can Ms Harper say something about the sorts of costs and which part of the amendment, in which part of the amendment can she see any scope for a reduction in costs?
So it has been pointed out to me that because of the requirement of training of health professionals, whether they're carers, whether they're registered nurses, whether they're people just entering someone's home, they would need to be provided education. So I don't know the direct costs at the moment, but my understanding is that that would cause potentially a cost burden to the member's bill. So that's why I'm happy to make this a probing amendment for discussion and then hear what the member has to say.
Thank you. Brian Whittle to speak to Amendment 161 and other amendments in the group.
Thank you, Convener. Can I start just saying I welcome Pam Duncan Glancy's 220, very powerfully spoken to, and I would also commend the work that Tanny Gray-Thompson has done, having sought her advice. She's a very powerful advocate in this particular section. I would say that I would welcome engagement cross-party and probably more importantly from the Scottish Government when we get to stage 3. I do recognise that the Government is neutral. That doesn't mean they can't advise on operational challenges that these amendments can bring, and arguably by failing to do so, I think they would effectively be acting against the bill. And if the bill is going to be the best it can be, it must also be deliverable, and the Government needs to advise where it would not be deliverable. I know, as I will declare my position, I have not decided my position at stage 3, and in considering all amendments, all I'm trying to do is seek to make the bill the best piece of legislation it can possibly be. Now, amendments in this group are brought forward because my concern was that an individual who may have a moral or personal reason to oppose the decision of the person who has made an assisted dying declaration could actually use the police or court system to delay the process through a protracted investigation resulting from an allegation of coercion. 161, 164, 169, 172 and 174 creates a mechanism for review independent of the medical profession for uses in cases where people who are close to the patient, that would be family, named friends or carers, suspect or allege coercion. I've tried to model this on a similar independent assessment model for organ donation, which also has a 10-day reporting time. 162 is reports should be referred into the medical professional or police where appropriate. And 210 gives the ministers flexible powers to bring forward the model. And these are only triggered when those close to the patient express that concern. And the 10-day reporting time is also in an effort not to prolong the suffering of the person wishing to assess assisted dying. And really the driving force behind this was that realisation that as it currently stands, if somebody tries to access assisted dying and there is an objection from a relative, a close friend, they would be able to wrap up that in a legal court case, because it would be the police's duty-bound to investigate any kind of these allegations, and I think we all would recognise the length of time that can take, by which time the person who has tried to access assisted dying may be unable to comply with the rules and regulations, or indeed may have passed away, given some of the time that these things can take. So really these are around trying to protect the person who's wishing to access assisted dying, make sure they don't have excessive suffering. Convener.
Thank you, Mr Whittle. Liam MacArthur to speak to Amendment 42 and other amendments in the group.
Thanks, Convener. Can I start off by echoing Brian Whittle's comments in relation to Scottish Government engagement in this process? I'd have to say that my conversations with the Scottish Government have been constructive throughout. But I think it is important, for the very reasons Brian Whittle indicated, that notwithstanding neutrality, there are issues in terms of the operability of the legislation that members across Parliament would welcome, I think, Scottish Government's views on now, but certainly ahead of and during stage 3. So can I very much echo those sentiments. Can I maybe start by addressing my amendments and then go on to address the amendments lodged by other colleagues in this group? My Amendment 42 extends the Section 21 offence to cover the day of death when the coordinated registered medical practitioner or authorised health professional provides the substance to the person. There's no change to the penalties set out in Section 21(2). Amendment 43 is a drafting consequential. Section 21 makes it an offence to coerce or pressure a terminally ill adult into making a first or second declaration. This amendment adds a new offence of coercing or pressuring a terminally ill adult into the act of using an approved substance. The bill as introduced requires the coordinating registered medical practitioner or authorised health professional providing the substance to the person on the day of the intended assisted death to be satisfied that the person is not being coerced before providing the substance. However, coercion at that point is not covered by the offence in Section 21. This amendment therefore ensures that a situation where a person has not been coerced or pressured into making a first or second declaration, but is subsequently coerced or coercion is suspected on the day into self-administering the substance, is made an offence. If coercion is discovered after the terminally ill adult has died and it can be shown that the person has was coerced into using the substance, the offence remains prosecutable, and this may then also trigger a homicide investigation. This, therefore, further strengthens the safeguards in the bill. It also brings the bill more closely in line with the bill at Westminster as it currently stands. Turning to the other amendments in this group, with regards to Amendments 220 and 223 from Pam Duncan-Glancy, I'm content that my bill has safeguards in place to ensure that a person seeking an assisted death has not been unduly influenced. I'm also concerned that these amendments may make doctors hesitant about discussing assisted dying with their patients, thereby limiting the information available. I note that the BMA have been unequivocal on this, stating, and I quote, "Doctors should be able to talk to patients about all reasonable and legally available options. A provision that limits or hinders open discussion about any aspect of death and dying is likely to be detrimental to patient care." With regard to Amendments 237 and 238, my bill provides that the registered professional medical statements must set out that the person made the declaration voluntarily and has not been coerced or pressured by any other person into making. I'm not convinced there would be value in adding another similar statement. Moving on to
Member take an intervention?
Briefly, yes.
thank the member for taking that intervention. Can the member therefore set out what aspects of his bill he thinks are there to safeguard against that coercion that could be experienced by disabled people?
Well, I think I've explained the fact that the conversations that are had as part of the assessing the rationale for why a declaration has been, or a request has been made, are not happening at the moment. I think they therefore provide not just protections under the provisions of this under this legislation, but also extend those protections far more widely to those who are left vulnerable at the moment. Moving on to Amendments 85, 86, 8, 104, 105, 107, 112, 118, 120, 124, 139 and 140, lodged by Bob Doris. I consider that personal choice, autonomy, is at the heart of this bill, providing appropriate and proportionate safeguards, whilst allowing those who wish to have assistance to be able to access it in a reasonable time and within a reasonable framework. It's fundamental that a terminally ill adult makes the choice about requesting assistance themselves without coercion or pressure by another person. The bill is clear on that and provides for it and makes it an offence to coerce or pressure a person into requesting assistance. I've also lodged an amendment, as I've said, to add an offence of coercing or pressuring a person into using an approved substance. However, I'm very wary about widening coercion and pressure from some form of illegitimate influence being brought to bear by another person to being done by the person themselves, by societal expectations, the health and social care system, as opposed to individuals within that system or the state. I'm concerned that defining coercion and pressure in such a way risks introducing new definitions of legal terms, creating confusion and making the detection of coercion or pressure and the prosecution of offences in the bill more difficult. I understand what the member is getting at with these amendments, and I understand that there are various factors that may express a person's vulnerable status and situation, which would potentially make them prone to influence and could affect their decision-making. However, I believe that retaining the need for coercion or pressure to be an act done by another person, supported by the offences in the bill and the ability for other health, social care and social work professionals to input into the assessment process, is the best way to proceed. With regard to Emma Harper's amendment, briefly, Bob Doris, yeah.
So clearly I'm disappointed that Liam MacArthur's not persuaded by being consistent on using the GMC definition of coercion, which was mentioned in the member's policy memorandum, but doesn't appear on the face of the bill. My amendment would seek to place that on the face of the bill. Could Mr MacArthur outline to me what's wrong with the GMC definition of coercion that seems to be suitable for almost all other areas?
I would respond to that by saying there's nothing wrong with that guidance. It is consistent with the approach taken in the bill, and the discussions that and my team have had with SPPC around this has yet to determine where that difference is. I will continue those discussions with SPPC and indeed with Bob Doris to establish whether or not there's more that can be done. But as yet, I have not seen the evidence that shows the disconnect between those. As Mr Doris acknowledges within the explanatory notes, there is specific reference made to that guidance. Turning to Emma Harper's Amendment 12, I support the assessing doctors being required to make inquiries of those that are providing or have provided health or social care to the person, and also consider that that should include social work services as well, if they consider it would be helpful, and also having the option to make inquiries of health and social care and social work professionals on any matter relevant to an assessment they are making. This includes input which may be helpful from people who have provided care to the person and will know them to an extent and may have seen them interact with family, friends on matters where coercion may be relevant. I note that Amendment 12 is preempted by Amendment 88 in Group 10 on assessments of the terminally ill adult. However, I can consider that this potential input should include social work services, which this amendment does not, and should also extend beyond being limited to the matters of coercion. My own Amendment 69 requires assessing registered medical professionals to make inquiries of social care, social work and healthcare professionals who have provided care to the person if they consider it appropriate, and also allows assessing registered medical professionals to seek input from health and social social care and social work professionals on any relevant matter at assessing stage. This will include seeking input on potential or suspected coercion. These same points apply to Emma Harper's Amendment 13, and so while I'm grateful for in lodging those amendments enabling this debate to take place, I would ask her not to press and for the committee to support my Amendment 69. If there's further work that needs to be done ahead of stage 3, happy to work with Emma Harper on that. With regard to Brian Whittle's amendments 161, 162, 172 and 210 and amendments 164, 169 and 174, it's fundamental that a terminally ill adult makes the choice about requesting assistance themselves without coercion or pressure by another person. The bill is clear on that, provides for it and makes it an offence to coerce or pressure a person into requesting assistance. Given that the coordinated registered medical professional and independent registered medical professional will already be assessing for signs of coercion, I think I would question whether a further assessment by an independent assessor is necessary. I would be concerned, in a second Mr Whittle, I would be concerned that this may create undue delays, prolong the suffering of the person seeking assisted death, particularly given that the period of 10 working days may pass following the assessment before the report is produced and not provide additional protection. And I'm happy to give way to Brian Whittle.
Thank you very much. I think the whole point of the amendments I put forward there are to try and counter any potential family member or whatever having a moral issue with a decision that somebody has made to access assisted dying, because if even though the medical professionals are that's their job to try and establish whether any coercion has been done, if somebody accuses of coercion, it is a legal responsibility of the police to investigate that, and that's the problem I'm trying to alleviate here, in that it doesn't matter whether the medical professionals decide that no coercion has taken place. If somebody says that it has, it's a legal responsibility, and that's the bit that would take the time, and that's the bit that would potentially impact the person seeking assisted dying.
Look, I thank Brian Whittle for that further clarification, and from the discussions I've had with him, I understand the motivation here, which is entirely, I think, constructive in intent. I think my concern would still be that the process is likely to delay any decision being taken forward, allow opportunities for family members who as he rightly says, may have their own views and strong views on the decision that the individual is proposing to take. I think the committee heard during stage 1 evidence from witnesses in Australia that actually, in terms of coercion, almost without exception, the coercion is applied in trying to influence an individual out of making that decision. So I think, unfortunately, this process, as I say, well motivated as it may be, it runs the risk of allowing that to be given effect. And I don't think that's in the interest of the patient, nor indeed family members or health professionals more generally. But I'm happy again to work with Brian Whittle if there are ways of trying to tease this out further ahead of stage 3. Finally, turning to Stuart McMillan's amendments to 216 and 217, and I recognise that I'm speaking before he's had a chance to present them, so I will bear that in mind and come in if needs be. But as with other amendments seeking to define coercion and pressure, my understanding is that the terms are well understood, both in the medical professional and by the courts, and do not require definition on the face of the bill. The committee heard at stage 1 about the existence of the guidance from the General Medical Council on the issue of coercion, and there appeared to be general consensus among expert witnesses, and acknowledged in the committee's stage 1 report that cases of explicit coercive behaviour should be relatively straightforward to detect. But I think some of the issues that have been raised in the context of the amendments here are ones that I would recognise. I think, as I said in response to Bob Dorsey's intervention, that my bill is consistent with that GMC guidance. If there is more that needs to be done in that area, I'm happy to work on that ahead of stage 3. Of course, there may be cases that are not straightforward, which is why the bill also allows for Scottish ministers to prepare and publish guidance on such matters, and why I've brought forward amendments to allow ministers to regulate for the training of a coordinated regulated medical professional, independent medical professional, and they should all have that training in order to fulfil those roles, in addition to the powers already given to ministers in the bill to regulate for qualifications and experience. And on that basis, I would encourage Mr Millen not to press his amendments to a vote, but encourage, if he does, for the committee not to support those. Thank you, Convener.
Thank you, Mr MacArthur. Stuart McMillan to speak to Amendment 216 and other amendments in the group.
Thank you, Convener. Certainly, notwithstanding Mr MacArthur's points a moment ago, so he may come in. One of the main points that's come up in my discussions with constituents and organisations over the last 4 years has been the issue of coercion. Notwithstanding, also Mr MacArthur's comments a moment ago with regards to the kind of well-defined and well recognised, and also in the guidance. The reason for bringing forward these amendments is just to try to have something on the face of the bill whereby the wider public can also have a full understanding of the situation. Because obviously, I think we would all recognise technically this is it's a normal bill going through the parliamentary process, but the subject matter is not a normal subject matter. I think certainly one of the points that really did it's come up a number of times in discussions with just that kind of element of kind of the smallest hint of disapproval from a loved one, the quiet suggestion that they're a burden, or even the unspoken weight of financial or emotional strain can influence a person's decision in ways that are almost impossible to measure now. And Bob Doris in his earlier comments did speak powerfully regarding the aspect of being a burden. Now, if coercion or pressure go undetected, then people may die, not because they wish to, but because they feel that they ought to. So the amendments 216 and 217 are just an attempt to try to address that gap by introducing a clear definition of coercion and also pressure into section 29 of the bill. Sure.
I really appreciate Mr McMillan taking an intervention and setting out the rationale for his amendments, which don't come as a surprise. It's an issue that he and others have raised. I think would he perhaps accept that the points that have been made by Bob Doris in relation to the guidance from GMC has a firmly established process of assessing coercion. We need to make sure that this bill is in alignment with that. I believe it is, but if there's further work that needs to be done to allow that to happen, I'm happy to take that forward. But adopting a different approach in relation to this is only likely to create uncertainty, confusion, and actually make prosecutions of offences more problematic. And that, again, isn't in the interests of patients, of their families, or indeed of health professionals who were asking to operate this system.
No, I appreciate the points that Liam MacArthur is making, and so I mean these amendments may, on the face of it, may seem to be kind of unnecessary, and judging by Mr MacArthur's points, potentially confusing from a legal perspective. However, I thought that the amendments actually were very much worthy of going forward. Certainly, first of all, to have that discussion at stage 2. And secondly, if they're not to be accepted, and also by Mr MacArthur, and also the committee will decide themselves, also when later on. But if I'd be quite content not to move them, but to work with Mr MacArthur on potentially something else for stage 3, because I generally feel that because of the subject matter, this is more than just a normal bill, and I genuinely believe that having that social consensus is extremely important if the bill were to pass and pass through stage 3 and also then become an Act of Parliament. I think having... Sure, okay.
I thank the member for giving way. I've really appreciated the exchange between yourself and Mr MacArthur, Mr McMillan, and it's again important. Mr MacArthur says he wants to align with the GMC guidance as it is. If Mr McMillan is seeking to withdraw these current amendments, is one solution to be to put the GMC guidance, which we all agree is the correct guidance, on the face of the bill to give the certainty that would be required, rather than finding a workaround. if the definition exists, why not put it on the face of the bill and apply it?
Sure. I'm happy to take Mr MacArthur first.
Using you as an intermediary between myself and Mr Doris here. I think this needs to be consistent with GMC guidance. As I say, I think consistency across other areas of healthcare is important, I think, in reducing the scope for confusion or uncertainty. So I'm happy to look at that. I think putting guidance on the face of the bill seems to me potentially problematic, but as I say, I'm happy to work with Mr Doris and Mr Macmillan on ways of trying to express this better if that is what is felt to be necessary. But that guidance, I am sure, will be updated as understanding of coercion develops, etc. going forward. So I think, as I say, putting it on the face of the bill may be problematic, but I understand the points that Bob Doris and Stuart Macmillan are making, and I'm happy to work with them ahead of stage 3.
Okay. No, I appreciate that, Mr MacArthur. Certainly, just I'll conclude, convener, that I generally consider, because of the subject matter of the bill, that social consensus is extremely important if the bill were to pass and become an Act of Parliament. And as a consequence, having that wider understanding of exactly what the Act would say. Hence the reason for also kind of bring the amendments forward in the first place, to try to have that, so the public can actually have that wider understanding, not solely those within the medical profession, but the wider public. So with that, I would be content to withdraw if we can work together on something else going forward. Okay.
Thank you, Mr Macmillan. Pam Duncan-Glancy to wind up and press or withdraw Amendment 220.
Thank you, convener. I also just to say that I had thought wrongly that Bob Doris's amendments 139 and 140 were in another group, or I would have said at the outset that I also think they're incredibly important. I think together with Stuart Macmillan's, they really get to the heart of some of the concerns that disabled people have about that kind of internalised ableism that does exist within society. And I have to say, a rejection of them and a rejection of any definition of coercion and a rejection of any other sort of process to determine it, including Brian Whittle's amendment, I think would be quite concerning, and I hope the committee will therefore look to support some of these amendments. I'd also like to draw the committee's attention to the Royal College of GPs evidence, which said that they challenged the assumptions that discussions around assisted dying could take place at regular GP appointments. And I quote, "This is a complex process, morally and emotionally, involving considerable time for technical assessment of capacity and coercion, which can be challenging. We do not believe that this work can or should be incorporated into already busy and stressed service without potential detriment to patient care." So that, I think, is an important reflection from the front line of professionals that, for us to bear in mind when we're considering the definition of coercion. The clearer we can be in this piece of legislation on that matter, the better. So I think the committee are grappling with two aspects of it. One, which is the definition of coercion, which is, in effect, there are several options available to the committee put out in the amendments. Some of them include the broader aspects that I think are essential to include. Some of them are more narrow, but nonetheless still define it. I think, given what the Royal College of GPs have said around the ability of professionals to incorporate such a difficult decision without clarity, I'd like to think that committee members will support it. I'd also like to just briefly comment on Amendment 13 and the concern that it may not be progressed at this point because of some of the issues with training and the cost of training health professionals. I think the cost of training health professionals for this legislation is a very legitimate point. For people to be able to do this, not only are they going to have time to do it, but they're going to have to be trained to do it. And there is a question as to whether or not we think that cost is something that we should be able to bear the brunt of. It will cost money. And I'd like to think that if there is a safeguard put in that we are going to put professionals in to be able to make these decisions, surely we therefore have to think that they will also have the appropriate training. And so even if my colleague Emma Harper didn't press it at stage 2, I'd like to think that something similar would come forward at stage 3, regardless indeed of the cost. And on that, the convener, I will press Amendment 220, please.
Thank you, Ms Duncan-Glancy. The question is that Amendment 220 be agreed. Are we all agreed? Yes. Committee is not agreed. There will be a division. Those in favour of Amendment 220? Those against? Abstentions? The result of the vote on Amendment 220 is 4-3 against 7. There were no abstentions and the amendment is not agreed to. I call Amendment 221 in the name of Pam Duncan-Glancy, already debated with Amendment 83. Pam Duncan-Glancy, to move or not move?
Move, Convener.
The question is that Amendment 221 be agreed to. Are we all agreed? No. We're not agreed and there will be a division. Those in favour of Amendment 221? Those against? Abstentions? The result of the vote on Amendment 221 is 0 votes for, 9 against and 1 abstention. Therefore, the amendment is not agreed. I call on Amendment 26 in the name of Liam MacArthur, already debated with Amendment 143. I remind members that if Amendment 26 is agreed to, I cannot call Amendments 84 or 222. Liam MacArthur, to move or not move?
Moved, Convener.
The question is that Amendment 26 be agreed to. Are we all agreed?
Yes.
We are agreed. Therefore, I can't call Amendment 84 in the name of Jackie Bailey. So we will move to question on Section 3. The question is that Section 3 be agreed to. Are we all agreed?
Yes.
I call Amendment 148 in the name of Murdo Fraser, grouped with amendments as shown in the groupings. Murdo Fraser, to move Amendment 148 and to speak to all amendments in the group.
Thank you, Convener. I have two amendments in this group, Amendment 148 and Amendment 208, which is consequential to 148. Amendment 148 seeks to establish a new statutory designated agency responsible for administering and overseeing the entire assisted dying process under the Act. This agency's duties include managing declarations, coordinating medical assessments, authorising practitioners, arranging assistance, maintaining records and report it. The designating agency will operate independently from the NHS with its powers, governance and procedures further defined by Scottish ministers through regulations. Functions performed by medical practitioners in the process would generally be under this agency's authority or delegation. What this amendment does, Convener, is address one of the deepest contradictions in this bill, the expectation that assisted suicide will be carried out within the framework of our National Health Service. The NHS was founded in the aftermath of the Second World War with a singular moral purpose: to preserve and protect life without distinction. It was a national affirmation that every life, regardless of age, ability or circumstance, was worth saving. And now to ask that same institution to facilitate the deliberate ending of life is to abandon that founding principle. Doing so would blur the moral and professional boundaries upon which public trust in the NHS depends. Patients turn to doctors and nurses believing that their sole purpose is to heal, to comfort and to preserve life. If the state asks them also to provide the means to end that life, that trust is fundamentally weakened, perhaps irreparably. Yes, I will. Yes.
Thank you. There is the Abortion Act that allows the NHS to perform abortions, and just on the point that you made about preserving life, that is contrary to it. So would you suggest that that is contravening the point of the NHS?
Mr. Dr. Gilhanley, for that intervention, I would suggest that the purpose of the Abortion Act was to protect the lives of mothers who, in many cases, were potentially at risk from continuing with a pregnancy. So I understand the point he's making, but I'm not sure it's salient to the argument I'm making here. So what my amendment seeks to do is establish a statutory independent body responsible for administering the functions of the Act, a body separate from the NHS, overseeing all aspects of the process, receiving and recording declarations, coordinating assessments, authorising practitioners, arranging for the provision of the approved substance, maintaining compliance and reporting outcomes. By creating an independent agency, we make a clear moral distinction between a service dedicated to preserving life and a mechanism authorised by the state.
Will the member take an intervention?
Yes, I will.
I thank Mr Fraser for taking an intervention. It's just so that I'm absolutely clear what he's proposing here. So he's proposing a body which is not part of the NHS, which is not under the remit of NHS Scotland, a separate body that would purely be tasked with enacting, should this bill pass, the Assisted Dying Act.
Yes, that's correct. That's the purpose of the amendment.
Thank you for that clarification.
A new standalone body regulated by Scottish ministers that would have the responsibility for conducting assisted death. I believe that by creating an independent agency, we create a clear moral distinction between the NHS and a new body established with a different purpose, which is to end life. And I do not believe the NHS should be asked to bear the burden of bringing in assisted dying. So I'd urge members to support this amendment to protect the integrity of our health service and the trust upon which it rests. Thank you, Convener.
Thank you, Mr Fraser. Jackie Bailey to speak to Amendment 62 and other amendments. Oh, sorry, Mr Fraser. Could you move your amendment?
Yes, moved.
Thank you. Jackie Bailey to speak to Amendment 62 and other amendments in the group.
Thank you very much, Convener. Amendment 62 and 63 has been laid after discussion with CHAS, that's the Children's Hospice Association of Scotland, who run Robin House in my constituency. Now, the bill as it currently stands doesn't contain any details about the regulation, scrutiny and inspection of organisations providing an assisted dying service, nor on reporting on the processes that they operate. And that happens in other types of care. So this would represent an unprecedented lack of regulation and scrutiny. Now, the requirement for regulatory arrangements needs to be made explicit on the face of the bill, because I think we all want to ensure patient safety and quality of service is of paramount consideration. So Healthcare Improvement Scotland, the Care Inspectorate, already ensure that non-NHS services are run by fit and proper people. They already have statutory powers to secure patient safety and significant experience of regulating the provision of social care and health care out with the NHS. They are also accountable. To be clear, that would not in any way prevent an assisted death in a person's home. It would simply ensure the organisation supporting this, if it isn't an NHS service or GP practice, meets all the standards and is safe. However, the amendment would allow the Scottish Government, indeed.
Can I just clarify that point? So, are you proposing that the assisted dying is not part of the NHS, and thus, as Murdo Fraser has suggested, have a regulatory body that goes with that, just because you spoke about not being within the NHS?
No, I am not proposing a separate regulatory body. I'm leaning into the current arrangements, and I'm allowing for the circumstance where it might not be entirely delivered by the NHS, which is the case in other countries. So it is belt and braces to make sure that we have the right regime in place that ensures that we are satisfied with the level of scrutiny and regulation that is there. So I hope that that's clear. So The amendment would allow the Scottish Government to bring forward regulations which prevent an assisted death taking place in certain settings. For example, it could be care accommodation for people aged 18, it could be a care service used primarily by children, drug and alcohol rehabilitation centre, supported accommodation for people with mental health illnesses, or indeed even a women's aid refuge. They are all registered care settings, but clearly providing assisted dying in them would not be appropriate. I also anticipate that the regulatory framework could make provisions where a person asked to undertake an assisted death in a public place or outdoors, a sensitive issue, and the Scottish Government should bring forward the details in due course through secondary legislation. I also would anticipate that the secondary legislation will clarify the issue of whether the service can be provided privately on a for-profit basis, because there are already legislative prohibitions on other types of care providers operating for-profit in Scotland, for example, adoption agencies. So in summary, it's about having the right safeguards in place, that we only allow reputable and regulated organisations to be involved, that there are standards set and oversight, and we are aligning it to existing bodies such as Health Improvement Scotland and the Care Inspectorate, with which we're all familiar. And I hope, therefore, that members can support 62 and 63, which provides for affirmative regulations.
Thank you, Ms Bailey. Bob Doris to speak to Amendment 128 and other amendments in the group.
Thank you, Convener. My Amendment 128 and consequential Amendments 138, 141 and 142 require that the Scottish Government must produce regulations about the regulation and oversight of persons who carry out assisted dying under the Act. The purpose of this is to ensure the safety and well-being of the people provided with assisted dying. Such regulation should include regulation of settings where assisted dying may or may not take place. Regulation should also include determining and making provision for the role of Healthcare Improvement Scotland and the Care Inspectorate within regulation and scrutiny. Regulation should also make provision for a process to raise concerns about the provision of assisted dying to a person. The bill is silent as it currently stands on institutional responsibilities for the delivery of assisted dying. It merely permits practitioners to provide assisted dying in certain circumstances. Even the most basic organisational model setting out duties and responsibilities is missing. This is something the Scottish Partnership for Palliative Care have concerns with regard, and I agree with them. The bill currently contains no requirements that the provision of assisted dying should be subject to any system of regulation or scrutiny. Whilst assisted dying might take place within the NHS, it may also potentially take place within the private or third sector, as Jackie Bailey was indicating in her contribution. Either way, there is surely a need to provide powers to scrutinise and regulate a life and death activity such as assisted dying. The bill makes no provision for a process by which people may raise concerns about the provision of assisted dying to a person. It is likely that some people may from time to time wish to raise a concern about the assisted dying process and the provision of assisted dying to a person in a specific instance, or indeed to raise concerns about the role of any organisation facilitating assisted dying more generally. The bill should make provision for such a process. My amendments will therefore give powers to the Scottish Government to establish a system of scrutiny and regulation of assisted dying, and also to establish a process by which people can raise a concern about specific instances of assisted dying process and provision. This would be established in regulations under the affirmative procedure and must come into force before other provisions within the Act can be enacted. Yes, of course.
Thank you. I'm curious about the aspect of Bob Doris's amendment which talks about regulations making provision about the types of settings or premises where functions under the Act can take place. And that seems very broadly defined. I think there is a legitimate discussion that we might have about whether there ought to be regulations on the settings or premises in which the final act under the action under the Act, the actual provision of an approved substance and its use by an individual should take place. There'd be a legitimate discussion about whether that should be defined. But it seems to me quite broad to say that any actions, any functions under the Act, including record keeping, the recording of statements and so on, there should be regulations about the settings and premises for all functions under the Act. Can Bob Doris explain a little bit more about why he's taken a very broad approach to that aspect?
I thank Patrick Harvey for that intervention, quite insightful. But what I would also say to Mr Harvey is that as the bill stands just now, there's quite a broad permissive attitude to where assisted dying can take place as long as the relevant procedures are followed. So by bringing in regulations which may decide whether or not it is or is not appropriate to, even if there's a standalone body, whether an NHS facility can be used, or whether a care home can be used that's run by the public sector, or anything that may come up in relation to what best practice would look like, and where something or the process should be inspected where an institution is involved. So this is deliberately broad, Mr Harvey, but as I'm listening to you, I'm thinking that it still remains the right thing to do, and I'll certainly be pressing it here now this afternoon, not this morning. But given it's so broad, what I might do is hope to persuade the committee at this stage, and perhaps it has to become a super affirmative process rather than an affirmative process, to make sure we get full buy-in and look through all the possible permutation that come out from it. But it's deliberately broad because the provisions within the bill are deliberately permissive. So, you know, one, if you like, complements the other or counterbalances the other, in my view. Can I say a little about the amendments within the group, particularly from Murdo Fraser's Amendment 148, which sets up a designated statutory body out with the NHS to be responsible for pretty much all aspects of assisted dying. We've heard some of the rationale of that from Mr Fraser. I think as we go forward, have to tease out whether the NHS would indeed still have a role, and what the inspection and oversight of that body itself would look like, and could NHS staff and buildings still be used on a contracted basis. So I think that much more information would be required in relation to that particular amendment, and also how concerns could be raised regarding the operation of the new body's functions and carrying out its responsibilities. Jackie Bailey's Amendment 6.3 appears to have similar policy intent to my own, I think, from listening to Jackie Bailey. It requires the Scottish Government to make regulations about the provision of assisted dying where it takes place out with the NHS, including a role for the Health Improvement Scotland and the Care Inspectorate. And I note my amendment would, unlike Ms Bailey's, make an explicit provision for raising concerns, if I've captured that correctly. However, there appears to be no preemptions here, so it does not appear that committee members need to choose between either or in relation to this. Finally, Fulton McGregor's Amendment 256. I won't progress that at the moment. I feel, Convener, nearly upgraded to presiding officer there, and I'll rest my comments at that because of time.
Thank you, Mr Doris. Fulton McGregor to speak to Amendment 256 and other amendments in the group.
Thank you, Convener. Good morning, folks. Amendments 256, 257 and 277 in this grouping have been laid with the support of Scottish Association of Social Work and, of course, the help of the legislation team. What would we do without them in these situations? And I want to just put on record my thanks to both. These amendments are about ensuring that if Parliament chooses to legislate in this area, the practical delivery of assisted dying services is fully integrated with Scotland's existing health and social care framework, using the structures that already exist to manage and oversee sensitive health functions, rather than creating a new standalone system. I think all members here will agree that this bill, by its very nature, demands clarity, accountability and public confidence in how it would operate in practice. And these amendments, I hope, are intended to provide that. Amendment 256 would make a small but important technical change to the Public Bodies Joint Working Prescribed Health Board Functions Scotland Regulations 2014, easy for me to say. That set of regulations lists the functions of health boards that are included in local integration schemes, the partnership arrangements between health boards and local authorities that underpin how health and social care are jointly delivered in Scotland. By adding the Assisted Dying for Terminally Ill Adults Scotland Act to that list, the amendment ensures that any functions health boards have under this bill will be automatically captured within the existing integration framework. And this means that planning, oversight and reporting of any assisted dying service would take place within the same governance structures as other key health and social care services, and subject to the same accountability mechanisms and local partnership scrutiny. And that's important because it helps ensure there is no fragmentation or confusion about who is responsible for delivering or overseeing these services, it situates them firmly within the public system where clear lines of responsibility and accountability already exist. Amendment 257 builds on this by requiring each health board to establish a specialist assisted dying service for its area. This is again about consistency and quality of provision across Scotland. It ensures that wherever a person may live, there is defined and accountable service in place, one that can support individuals, coordinate with local partners and ensure that the requirements of the Act are applied safely and consistently. And it's... Yep, no problem.
I just wonder if 257, if you didn't have 257, how would you envisage the NHS would work and function to provide an assisted dying? Would this... So, sorry, my question is, does this need to be on the face of the bill? Is this not what would happen anyway?
Well, I thank the member for that intervention, but he might be interested to note that 257 is strongly supported by the Royal College of Nursing, who state that they support the requirement for each health board to set up specialist assisted dying services to deliver the functions of the Act. And also, he might be interested to note that the Royal College of General Practitioners also strongly support this amendment, given his background. And I think that these are two very strong endorsements for that. Yep, no problem.
I thank the member for taking the intervention, and I genuinely understand the intention of this, in particular Amendment 257, given the points I made myself on the record earlier about the Royal College of GPs. But can I ask the member, within both of these amendments, does the member worry that having a similar duty on assisted dying within the Public Bodies Joint Working Act, that will mean that there will be the scrambling for funding for other services that are also subject to those acts, could mean some money would be moved from things like social care services to services to assist people to die?
I think it's a great point raised by the member. I thank her for that intervention. I think these are decisions that, if the bill is passed and comes into law, needs to be made between government and health boards in collaboration with each other, as they do for other services just now. But I do think it's a good point that's well made. If we could just continue on, Convener, the model also recognises that the importance of choice for staff. I think that's an important thing. I know the committee's looked at it. The development of a single dedicated service ensures that those who work within it have actively chosen to do so, meaning that any staff who have a conscientious objection to assisted dying are not placed in a position where they feel pressure to participate, whether that due to workplace expectations or out of a sense of duty to the people they support. At the same time, subsection 2 of this amendment gives Scottish ministers the ability to make further provision by regulation about how such services are to be delivered. That ensures that detailed operational guidance can evolve as needed, subject to parliamentary scrutiny, and that could perhaps take into account how things are operating in practice, as Pam Duncan-Lancy mentions there. Finally, Amendment 277 is a straightforward consequential provision which simply adds the regulation-making power under Amendment 2573 to the Bill's main list of regulation powers. It's a tidy-up measure to make sure that all delegated powers are properly captured. Taken together, these amendments are not about altering the principle of the Bill. They're about ensuring that if the Bill proceeds, its delivery is effective, transparent and safely governed. They build on the model of partnership and integration that Scotland has spent years developing across health and social care, recognising that issues of life, death and well-being cannot be neatly separated between services, but require collaboration, consistency and compassion. By placing assisted dying services within that existing framework, we help ensure that oversight is robust, that the public can have confidence in how the law would be implemented and that those working within the system are properly supported. These, I believe, committee are proportionate, practical and responsible amendments designed to strengthen the Bill's administrative foundations while maintaining its focus on dignity, safety and accountability, which the member has always had at its heart. So I hope that members can support these amendments today. Thanks.
Liam MacArthur.
Thanks very much. Can I start by agreeing with a final sentiment from Fulton McGregor about the way in which we embed the service? I think that is crucially important. Can I thank other colleagues for setting out the rationale for their amendments as well. Turning first to Amendment 148 from Murdo Fraser and to the issue of the administration and regulation of assisted dying services. The bill does not expressly establish a system within the NHS. It provides for a process with roles for health, social care and social work professionals. Public Health Scotland also has a role in data gathering and reporting. However, my view throughout has been that assisted dying services under the bill should be provided predominantly through the NHS, although can also envisage that there might be scope for it to be provided in some private settings as well. I'm concerned, however, that the implication of the approach proposed by Mr Fraser would potentially exacerbate inequalities of access, while also disrupting existing pathways for treatment and care at a point where the individual is perhaps least able to cope with that. Along with the consequential Amendment 208, I note the Scottish Government's concerns around competence, but also the possible duplication of roles of Public Health Scotland and Scottish ministers. This, to some extent, also applies to Jackie Bailey's Amendment 62 in terms of the provision of assistance out with the NHS. I note Amendment 63 is consequential and proposes related regulations being subject to the affirmative procedure. I listened to Jackie Bailey's response to interventions, but also the comments that she made. I think I understood that this is not seeking to set up a service out with the NHS, which I'm reassured about. I think the points she makes in terms of regulation are fair and reasonable. It probably leads me back to the point that Brian Whittle was making earlier about the engagement with the Scottish Government. I think this is one of those areas where engagement with the Scottish Government about operability of the system would be very welcome, certainly ahead of and during Stage 3. I'm committed to doing that and happy to work with Jackie Bailey on these provisions and others that may relate to the similar issues. Turning to... Yeah.
I'm sorry, just to clarify so that I'm clear what the member is saying. Is the member saying that he's not supporting the amendments from Jackie Bailey at this point, but willing to explore the issues further? Is he resisting the amendments, or is he ambivalent on it?
Never ambivalent, Patrick Harvey. You will know that. No, I think what I was saying is that I'm reluctant to support the amendments as they are framed, but I think Jackie Bailey was raising some reasonable points in relation to the regulation, particularly out with the NHS. I think the point Fulton McGregor was making about embedding a service within the NHS, with the protocols and all the rest of it that's there, I think is the most appropriate route to proceed along. But I think, as I say, the point that Jackie Bailey was making about those out with the NHS, I think are reasonably and fairly made. Turning to Bob Dorsey's Amendment 128, noting that Amendment 138 is consequential to ensure related regulations are subject to the affirmative procedure, or possibly bumped up to super affirmative procedure on the basis of his earlier comments. I'm keen to ensure the safety and welfare of anyone seeking assistance under the bill's provisions, and believe the bill includes safeguards to ensure this happens. I would note that health professionals who choose to participate in assisted dying are already regulated by the General Medical Council, which provides robust oversight. I would also acknowledge that there are mechanisms already for raising concerns about health social work professionals, and I would be, I think, concerned about setting up dual running processes which can only add to confusion. I'm not persuaded of the need or appropriateness of ministers being required to create an exhaustive list of where assisted dying can take place, for many of the reasons that Patrick Harvey, I think, alluded to in his intervention. With regard to subsection 3 of Amendment 128, I would remind the committee that there are already established mechanisms, as I say, for raising those concerns. In terms of the linked amendments on this issue, Amendments 141 and 142, I have serious reservations about the commencement of the substantive provisions of the bill being subject to the regulations provided for in Amendment 128. I believe, as with other amendments which seeks to prevent the Act being able to be properly implemented, this risks an unacceptable delay to providing those who wish to have and need assistance being able to request it. The Scottish Government has
identified... The member take an intervention on that point?
Briefly, yes.
And I understand the member's view, but does the member not think that it's not an unacceptable delay, it's a necessary delay, surely, to have those regulations in place before the Act commences?
I think there are a number of areas where provisions are contingent upon other things happening. I would be very, very cautious about proceeding on that basis. We will have debates around that, I'm sure, in relation to future groupings, but I've set out my concerns in relation to that point. Very briefly. Yeah.
So is the member suggesting that he would support the provisions of the Act being undertaken in an unregulated way?
What I'm saying is that there is plenty of scope within this bill for instructing or requiring ministers to take forward secondary legislation and working with healthcare and other relevant stakeholders, as well as in requiring professional bodies and others to bring forward guidance. I think the public, we as parliamentarians, would expect that to take place in a timely fashion and allowing the bill to proceed. But I would be reluctant to link the provisions as is set out in 128 to commencement of the bill. Very briefly, Bob Doris.
So I thank Liam MacArthur for taking the intervention. I suppose primarily it's to reassure Mr MacArthur, notwithstanding his lack of support for my set of amendments, that the commencement order was not intended for any undue delay or raking amendment in the slightest, but rather the underlying principle that we should decide what regulation looks like, bring it into force before assisted dying comes forward. So it's a sequential amendment rather than any blocking amendment. I think that's an important point to make.
Bob Doris for making that. That was not the implication of my remarks, but I think it's very helpful that Bob Doris sets that out, and I take that in the spirit in which it's. I'm going to proceed, I'm afraid, Mr Buffer. The Scottish Government has identified potential legislative competence issues here. I'm aware that the Scottish Government is working with the UK Government to ensure the full operation of the bill should it be passed. While the Cabinet Secretary is not here to update on those discussions, I think it's important to acknowledge the issues raised by these amendments. Amendment 256 amends the Public Bodies Joint Working Prescribed Health Board Functions Scotland Regulations 2014 to add in the Act, and I'm supportive of that amendment. In terms of Amendment 257, I've always taken the view, I think reiterated by Sanders Gulhandi earlier, that it is for the healthcare sector to determine how to manage the assisted dying process within the parameters of the bill. And I think that was something that Fulton McGregor went on to acknowledge in his own remarks. Therefore, my feeling is that it should be left to the health and care sector to determine whether it would be appropriate for each health board to set up a specialist assisted dying process. The amendment mandates every health board to set up a service, while Amendment 256 then mandates joint working with the local authority. I do wonder if these amendments are proportionate and not overly restrictive. I understand absolutely what Fulton McGregor is driving at and the reasons why RCN and others are wanting to see these amendments lodged and carried. There are certainly examples in other jurisdictions where provision is mandated in similar ways, ostensibly to ensure access. So I'm happy to work with Mr McGregor ahead of Stage 3 to see if something perhaps more proportionate might be achievable. Amendment 277 is consequential to ensure the related regulations. Yeah.
The intervention is one more of clarity. Liam MacArthur, I'm wondering, are you saying just now that you support 256, but you would want to work with me on 257? Is that correct? It just helps me in terms of whether I push it or not just now.
Yeah. No, certainly with 256 I would support. In terms of 257, as I say, I think there's an issue around proportionality. I think there are examples of where similar provision is made in other jurisdictions for reasons to do with guaranteeing access. As I say, I'm more persuaded of the rationale for allowing those within the sector to develop the model, and I think certainly my evidence to the Health Committee at Stage 1 acknowledged that in different parts of the country this service will look and feel different because of the circumstances each will need to deal with, and that is happening day and daily within health and care. So I understand the motivation, I understand why RCN and others are looking for this provision. As I say, as it stands, it feels like it may be disproportionate, but I'm certainly very happy to work with Fulton McGregor ahead of Stage 3, see if something can be worked up that might address those concerns. And with that, I conclude my remarks.
Thank you, Mr MacArthur. Murdo Fraser to wind up and press or withdraw Amendment 148.
Thank you, Convener, and thanks to the colleagues who commented on my amendments. I'm grateful to Bob Doris for his comments. I think he makes a reasonable point about the additional detail that might be required here, and I think should this amendment be successful at stage 2, there will be an opportunity to address some of these concerns in amendments at stage 3. I think there is an important point of principle here in relation to the correct placing of an assisted dying service, whether it should be within the NHS or not. I am very much aware there are many practitioners in the NHS deeply uncomfortable with the concept that the NHS that they've joined in order to save and preserve life should have a service as part of it that is committed to helping people end their lives. And I think there'd be many in the NHS who therefore would be much more comfortable if there were a separate standalone service providing assisted dying rather than it being part of the NHS. And I would just remind members, and I'm sure they're aware, that the Dignitas service that operates in Switzerland, which people in this country will sometimes avail themselves of, operates not in the public health sphere, but as a private service, I understand. So there is precedent for services to be provided in different ways elsewhere. So I think it makes an important point of principle, Convener, and for that reason I would press the amendment.
Thank you, Mr Fraser. The question is that Amendment 148 be agreed. Are we agreed? Committee is not agreed. We will therefore have a division. Those in favour of Amendment 148? Those against? Abstentions? The result of the division on Amendment 148, 0 for, 9 against and 1 abstention. Therefore, the amendment is not agreed. I call Amendment 149 in the name of Murdo Fraser, grouped with amendments shown in the groupings. I point out that if Amendment 32 is agreed to, I cannot call Amendment 170 due to preemption. Murdo Fraser to move Amendment 149 and to speak to all amendments in the group.
Thank you, Convener. What the amendments in this section seeks to do is replace previous provisions on proxy signing and limits the signing of declarations under this Act to the declarant themselves or, where the declarant is physically unable to sign, to a notary public acting as a proxy. The notary public must verify identity, ensure comprehension and voluntariness, affix their notarial seal and record their involvement in medical records. These safeguards aim to ensure the integrity, authenticity and legality of the declaration process. Now, I should, Convener, declare part of an interest. I am a member of the Law Society of Scotland. I used to be a notary public, but because I do not have a practicing certificate, I no longer hold that office. So this is not a job creation scheme for notaries public, to reassure you. But what this amendment intends to do is address a fundamental weakness in the bill, which is what is, in my view, the dangerously low threshold it sets for proxy signings. Under the bill, as it stands, a declaration to end one's life can be signed on an individual's behalf without the involvement of a notary public or any equivalent legal safeguard. And that might be acceptable in routine matters of administration, but not in a matter of life and death. I will.
How many copies do we have from Scotland, and is it readily available?
Thank you, Dr. Honey, for that intervention. I couldn't give him an exact number, but all practising solicitors who hold a practising certificate are routinely notaries public. So if he could check how many solicitors there are in Scotland, you'll find invariably all solicitors are notaries public. Now, across Scots law, an act that has serious legal consequences, such as signing off an affidavit, is a standard practice to require the oversight of a notary public. Yet this bill, which deals with the very serious matter of ending a human life, demands far less, and that, to me, presents a profound inconsistency and an unacceptable risk. and this amendment therefore ensures that the highest legal standard is applied to the most serious of decisions. So where a declaration is made under this Act, it has to be required either by the individual, him or herself, or where that's physically impossible, by a notary public acting as proxy. That notary would be required to verify the person's identity, confirm their understanding, affix their official seal, and ensure that their involvement is recorded in the individual's medical records. These safeguards are not bureaucratic obstacles. They are protections against coercion, conviction and abuse, and they uphold the principle that when the state authorises the ending of a life, that process must meet the highest conceivable standards of legal integrity. Yes, I will.
I'm grateful. I hope we would all agree that if legislation of this kind is passed, it shouldn't, or we should try to avoid as much as possible incurring any financial cost to individuals. Can the member explain whether there would be a financial cost involved in notaries public providing that service, and if so, how we expect it would be met?
I thank the member for that intervention. That is a matter which, as the procedures for assisted dying were progressed, would have to be agreed. Generally speaking, notaries public are private individuals operating in firms of solicitors. They would normally make a charge for witnessing documents. That would not, in my experience, be a large charge. It would tend to be a modest charge, but the cost of that would have to be borne in mind. But this is about putting in an important safeguard to ensure that there's additional protection in the event where somebody is using a proxy as opposed to signing on their own behalf. So, Convener, I think there's an important safeguard to ensure that this bill is safe where individuals are having a proxy declaring on their behalf. Thank you.
Thank you, Mr Fraser. Can you move the amendment?
Indeed, I'll move Amendment 149.
Thank you very much. Liam MacArthur to speak to Amendment 32 and other amendments in the group.
Thank you, Convener. And can I start by thanking Murdo Fraser for setting out the rationale for his amendments in this group and for his declaration of interest, which again I take in good faith. The bill requires the signing of a first and second declaration form by a terminally ill adult to be witnessed and signed by the coordinating regulated medical professional and another person, which for the second declaration cannot be the other regulated medical professional who assessed the eligibility of the person. Following discussions with the Law Society, who had concerns about the way this was framed in the bill, to some extent along the lines that Murdo Fraser has referred to, and the potential implication of creating a relationship between solicitors and individuals. I brought forward Amendment 32, which changes the definition of who can be a proxy, replacing the definition in the bill with a definition which requires the terminally ill adult to have known the proxy for at least 2 years, or for the proxy definition to be specified by Scottish ministers in regulations. Amendment 45 sets out that this would be subject to the negative procedure. Schedule 5 sets out who is disqualified from being a proxy. This includes family members, those who would benefit financially from the person's death, and a medical professional who has treated the person for the terminal illness. The conditions in Schedule 5 remain and should therefore be read with this amendment. I note that the amendment would preempt Mr Fraser's Amendment 170. In relation to that amendment, in my view, the proxy role should not be limited only to a notary public. Doing so might risk it being difficult for a terminally ill adult to engage such a person who may perhaps be needed urgently and or at short notice, and thus possibly adding to a terminally ill person's stress and anxiety. Amendment 45 is consequential and ensures that the regulations that Scottish ministers can bring forward under the amendment are subject to negative procedure. Turning to the other amendments in the group, which I will discuss together, as the role of an independent witness to the signing of the forms, in addition to the coordinating regulated medical professional, is just that, to witness the signing by a terminally ill adult. I see no reason why a notary public should also be required to witness, as set out in the other amendments in this group. As I've said, we need to ensure proportionality and that safeguards are not simply barriers in the way to eligible adults accessing the choice to which they should be entitled under this legislation. So I would urge Mr Fraser not to press his amendments, but if he does so, I would urge the committee not to support them. Thanks, Convener.
Thank you, Mr MacArthur. Murdo Fraser to wind up and press or withdraw Amendment 149.
Thank you, Convener. I'm grateful to Mr MacArthur for setting out his arguments. I would just reiterate that my amendments only apply in the event of an individual appointing a proxy. And I think there's a need for an additional safeguard in that particular circumstance, not where somebody is declaring on their own behalf. And on that basis, I'd like to press my amendment.
Question is that Amendment 149 be agreed to. Are we all agreed? No. Committee is not agreed. There will be a division. Those in favour of Amendment 149? Those against? Any abstentions? Thank you. The results of the vote on Amendment 149, there was 1 vote for, 9 against, no abstentions. Therefore, the amendment is not agreed to. I call Amendment 150 in the name of Murdo Fraser, already debated with Amendment 149. Murdo Fraser to move or not move?
Not moved.
I call Amendment 223 in the name of Pam Duncan Glancy, already debated with Amendment 220. Pam Duncan Glancy to move or not move?
Move, please, Convener.
The question is that Amendment 223 be agreed. Are we all agreed? No. Committee is not in agreement, therefore we'll move to a division. Those in favour of the amendment? Those against? Any abstentions? The result of the vote on Amendment 223 is 1 vote for, 8 against, 1 abstentions, and therefore the amendment is not agreed. As we've come to a different section of the bill, I would propose that we end our meeting today and return next Tuesday for further consideration of the Assisted Dying for Terminally Ill Adults Scotland Bill, and that concludes our meeting today.